you get a signal to stop if you run out of time, but you keep going. So don't do that. Stop if a scorer says stop. That's important from the scoring standpoint. But most important is don't, get done what you need to get done in your questioning or your statement or arguments in time. Get a signal to. I'm sorry. Oh, okay. All right. Let's go ahead and swear in anybody. Amy, I had this question yesterday. Do I need to swear in, or should I swear in the gallery?
You can if you want. Elsa did it yesterday, but it's kind of however you feel.
Well, I don't see any need to do that in this context. Okay. Team members, please raise your right hands. Do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Okay, all right, thank you. Scoring panelists, raise your right hands. Do you promise to adjudicate this mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial tournament?
Yes, Your Honor.
Okay, thank you. Now, witnesses, would you raise your right hands, please? Do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts, procedures, and rules of the mock trial competition? All right, thank you. I would like now for the teams to introduce themselves. And what I'd like to do, I want to make sure you do, is provide your real names to me and the roles you're going to play.
Judge, can I interrupt you for 1 second? I've got a Jeff Romine here. Jeff, are you a scoring panelist?
No, I just joined following the path, so I'm a parent.
You need to jump out of here and go to the YouTube live.
Okay. Oh, okay.
Okay.
Thank you.
Thanks. Sorry about that.
Okay. Okay, well, let's go through the introduction, starting with the prosecution.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Skylar Walta. Today, along with my co-counsel, I'm representing the state of Colorado in the matters of the state versus Avery Becker. I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Avery Becker. Permission from my co-counsel to introduce themselves, Your Honor.
Yes, please.
Good evening, Your Honor. Ladies and gentlemen of the jury, opposing counsel. My name is Ahmad Dar, and I will be an attorney for the prosecution. I will be doing a direct examination of Detective Jordan Markowitz, a cross-examination of Taylor Perkins, as well as delivering the closing statements.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is JT Timmers, and today I will be conducting the direct examination of Ms. Kyle Cusack, the cross-examination of Blake Van Owen, and delivering the opening statement. Permission for our witnesses to introduce themselves?
Yes, please.
Good afternoon, Your Honor, and members of the jury. My name is Stella Fenton, and today I am Detective Jordan Markowitz.
Good afternoon, Your Honor, and members of the jury. My name is Morgan Romine, and today I am Kyle Cusack.
Good afternoon, Your Honor, members of the jury. My name is Nathan Trong, and today I am Alex Cifuentes.
Okay, thank you. And I think I see, does the prosecution have a timer in the?
Yes,
this-
Your Honor.
Okay, Heidi Schmid, okay, thank you. Okay, defense. Please introduce yourselves.
All right. Good evening, Your Honor, opposing counsel and members of the jury. My name is Emily Bell. I will be conducting the closing statement, the direct examination of Avery Becker, and the cross-examination of Detective Markowitz. Permission for my co-counsel to introduce themselves?
Yes, please.
Hello, Your Honor, opposing counsel, ladies and gentlemen of the jury. My name is Jacob Behill, and I'm on the defense side for Avery Becker. I will be conducting the direct of Blake Van Owen and crossing Alex Cifuentes, as well as delivering the opening statement.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. My name is Sina Abraha, and I will be conducting the direct examination of Tyler Perkins and crossing Kyle Kuzik. Permission for our witnesses to introduce themselves?
Just a second, let me get caught up here. Okay, yes, please, witnesses.
Good afternoon, Your Honor and ladies and gentlemen of the jury. My name is Jake Lucko, and I am Blake Van Owen today.
Good afternoon, Your Honor, and members of the jury. I am Dominic Cincetti Gallegos, and I will be playing Taylor Perkins.
Good afternoon, Your Honor, and members of the jury. My name is Grace Magsman, and I will be Avery Becker today.
Your Honor, my name is Liam Slavin, and I will be the defense's timekeeper today.
Okay, thank you. Okay, defense witnesses. Or did we just did those, okay. Sorry, I'm used to looking at the scorecards, score sheets, or the rosters. And I don't have one yet. I wouldn't know how to pull it up anyway. Okay.
You can just click on the chat button and it should be there, and it'll just double click on it and it'll download it for you. The trial.
Okay. I think I've got the names and
Okay.
roles now anyway, but thank you. Okay. Does anybody have any, starting with the prosecution, any pre-hearing matters to bring up?
Yes, Your Honor. The prosecution requests that all jury instructions and stipulations be published to the jury. Furthermore, for the purposes of expediency, the prosecution requests that when evidence is admitted, it is constructively published to Your Honor and the jury. Also, for the sake of expediency, the prosecution requests that all exhibits are granted on a good faith basis for truth and accuracy, and therefore need not be presented to opposing counsel prior to presenting them to the court. We would
Okay, let's take those one at a time. And sorry, why don't you start over and I'll give the defense an opportunity to respond to each of them separately.
Yes, Your Honor. The prosecution requests that all jury instructions and stipulations be published to the jury.
Any
No
objection?
objection, Your Honor. No objection, Your Honor.
Okay, so ordered.
Furthermore, for the purposes of expediency, the prosecution requests that when evidence is admitted, it is constructively published to Your Honor and the jury.
Response?
No objection, Your Honor.
Okay, for that, on that issue, what I'd like to do, and let's see if we can do this, is have either an attorney or one of the timekeepers put the exhibit onto the share screen feature, and after the exhibit is admitted, I would like to just be able to treat that, the presence of that exhibit on the share screen as having been published both to me and to the jury. Is that an acceptable procedure for both sides?
Yes, Your Honor.
Okay. Your next preliminary matter?
Yes. Also, for the sake of expediency, the prosecution requests that all exhibits are granted on a good faith basis for truth and accuracy, and therefore need not be presented to opposing counsel prior to presenting them to the court. We would clarify that if opposing counsel has concerns about the authenticity of an exhibit, they object accordingly.
Any objection to that proposal?
Yes, Your Honor. So prior to an exhibit being admitted into evidence, we request that it is presented on the screen sharing mode so we can all refer to it.
Prior to its being admitted?
Yes, Your Honor.
Yeah, that's the intent. So when an exhibit is presented to a witness, it should also appear on the share screen.
Yes.
Is that do both sides understand that? It should go up immediately. And that'll be the equivalent not only of publication after it's admitted, but it will also provide the opposing party an opportunity to see it and to be ready to raise any objections to its authenticity or anything else. It's a compromise from regular courtroom procedure that I think it's easier on everybody if we do it that way.
Yes, Your Honor.
Is that acceptable?
Yes, Your
Yes, Your Honor.
Okay. Prosecution, any further preliminary matters?
Yes, Your Honor. The prosecution requests permission for our attorneys to either sit or stand while performing direct and cross examinations according to the space they are in.
Response?
No objection, Your Honor.
Okay, so ordered.
The prosecution requests to have our timekeepers share screen exhibits when they are shown to the witness on the stand.
I think we've covered that.
Yes,
So
Your
that one's acceptable.
And for the purpose of expediency, the prosecution requests that the time be paused while screen share is being prepared.
Any objection?
No, Your Honor.
The prosecution requests that any remaining time from the closing statement be reserved for rebuttal.
You're asking that that be done automatically without prior request?
Yes, we're requesting that any remaining time from the closing statement be reserved for rebuttal.
Okay, normally you need you're talking about the closing argument. Typically, the presenter, the attorney, should request that any time not used be reserved for rebuttal. But I think you are asking now that that be done automatically without a specific request by the presenting attorney. Do I understand that correctly?
Yes, Your Honor.
Any objection to that?
No objections, Your Honor.
Okay, so ordered.
And we ask that all rights afforded to the prosecution are accordingly afforded to the defense.
I'm sorry, I didn't catch that.
We ask that all rights afforded to the prosecution are accordingly afforded to the defense.
Any objection?
No objections, Your Honor.
All right. Okay, anything else from the prosecution?
No, Your Honor.
All right, thank you. Any preliminary matters from the defense?
Yes, Your Honor, just a brief one. So after an exhibit is admitted into evidence, we request that we can assume that everyone has the exhibit in front of them. We can refer to it directly through that instead of going through the screen sharing process again when referring to it after it's been admitted.
Well, any objection to that from the prosecution?
No objection, Your Honor.
Okay, well, notwithstanding that, I think it would be, since the time is paused, there won't be any downside. And I think if you're going to refer to an exhibit after it's been admitted, I would ask that it be pulled up so that it can be referred to and read by everybody, including me.
Okay,
So let's
thank you, Your
let's
Honor.
do it that way instead.
Thank you, Your Honor.
Anything else?
No further preliminary matters, Your Honor.
Okay. I've got a couple. My practice in judging these rounds is to provide time to the scoring panelists to assure that they are able to keep current with their scoring. And typically, I will pause between various phases of this proceeding. Almost always, I will pause between witnesses. There's kind of a natural break there, but also frequently I will pause between direct and cross, or between cross and redirect as well. And for timekeepers, those pauses should not count against either party. If you want to count them against somebody, count them against me. I can take it. But just so everybody understands what's going on, when there is a little bit of dead time, typically less than a minute, but it's important for this whole process that the scorekeepers be able to stay current in their scoring. So that's what's going on there, and that should not be counted against anybody as far as the time is concerned. Okay, let me see. I think that's all I have. Yeah. So, counsel, are you ready to proceed? Prosecution?
Yes, Your Honor. May I call Detective Jordan Markowitz to the stand?
Well, let's have opening statements first.
Sorry, got ahead of myself there.
I do that occasionally too, so don't let it bother you. Are you ready for opening statement, prosecution?
Yes, Your Honor.
Okay, please proceed.
This case is one of revenge. It is about a planned burglary gone wrong of a high school student, Avery Becker, who, angry with their mock trial coach, was pushed to the edge and acted on her anger. The people of the state of Colorado will call 3 witnesses to the stand today: Detective Jordan Markowitz, crime scene reconstructor Kyle Cusack, and a friend of Avery Becker, Alex Cifuentes. And from them, you will hear the evidence that establishes Becker's guilt. It is our burden as the prosecution to prove to you beyond a reasonable doubt that Avery Becker is guilty of felony murder in the 1st degree and 2nd degree burglary of a dwelling. And we are confident that the weight of the evidence we will present during the course of this trial will clearly establish the defendant's guilt. Now picture this. The defendant, Avery Becker, a high school senior who on multiple occasions came to high school mock trial practice unprepared and late, aggressively argued with Coach Mackenzie Brackman, the victim, leading to her eventual demotion to B team. Now this was the first push. You will hear about these events from Alex Cifuentes and about how Becker, angered by her demotion, took matters into her own hands. Becker asked her friend Taylor Perkins to leave the A team so that she could get her spot back for the upcoming tournament. Becker then, not learning her lesson, once again showed up unprepared to the competition, but she won anyway, further enraging Coach Brackman along with the other team members. Then at the following practice, the most heated debate of the season broke out between Coach Brackman and the defendant. Another push. Cifuentes will tell you how it ended with Becker storming out in fury towards Brackman's car with a permanent marker. When the coach and team got outside, they found Worst Attorney Award written on the victim's Porsche. Brackman then kicked Avery off of the mock trial team entirely. the final push over the edge. Avery desperately trying to get back on the team, doing everything from talking to Brackman herself to getting her friend Alex to talk to Brackman for her, but to no avail. Becker was so angry with Brackman's actions that while speaking to Alex again, she threatened to go and trash her former coach's house, as Cifuentes will show you. Then, on March 6, 2020, the defendant and her companion, Taylor Perkins, were not to be seen at school. You will hear from Detective Jordan Markowitz, who will present you with the cell tower data, and you will see why she believes that Becker was at the residence of Mackenzie Brackman at the time of the murder. You will also hear from Ms. Kyle Cusack, who will present her findings during her work reconstructing the crime scene. From that, you will be shown why she believes that the perpetrator that entered Brackman's house was not armed at all. Now, that same day, March 6th, sometime before 2:20 p.m., the victim, Coach Brackman, was murdered in his house. This is not the story of a serial killer and a murder, but of an angry person pushed to the edge and who is now paying the price. It is your civic duty to punish the person who committed this crime. In order for Becker to be guilty of second-degree burglary, she must have entered unlawfully or stayed unlawfully in the dwelling of Mackenzie Brackman with the intent to commit some form of property damage on March 6, 2020 in the state of Colorado. Then, if you believe at the end of this trial that Avery Becker is guilty of second-degree burglary, all that you have left to believe to convict Becker of first-degree murder is that Brackman died that same day. We are confident that after you have heard the evidence, you will find the defendant guilty of each count in this indictment, second-degree burglary of a dwelling and felony murder in the first degree. Thank you.
Opening by defense, please.
Yes, Your Honor. Good morning. Sorry, let me rephrase that. Good evening, Your Honor, opposing counsels, ladies and gentlemen of today's jury. We are gathered here today to ensure that a wrong is righted and brought to justice, to enact that the convicted are proved innocent. In the case of the people of Colorado versus Avery Becker, Avery Becker, a student at Colorado High School, has wrongfully been convicted of breaking into her mock trial coach's house, vandalizing his property, and murdering him. Ms. Becker seemed to have a life full of bliss and success, but with bliss and success comes envy. Mr. Cifuentes, one of Avery's classmates, was intertwined with envy against Becker's successful high school career, thus resulting in resentment towards Becker and a spiteful desire to ruin her reputation. Imagine two trees, both different and unique. One tree has been attended to, and therefore both strong roots. Then imagine a second tree, one that has been neglected and uncared for. As a result, there are no roots, but it is clear that the tree was neglected, resulting in envy and spite. While the prosecution's case will only wither during this trial, the defense will thrive. We are here to find out the truth, and we most definitely will. To prove that Avery Becker is not guilty, 3 witnesses will be called to the stand. First, the jury will hear from Blake Van Owen. Van Owen is a professor as well as an expert in police practices, use of force, false arrest, and forensic evidence techniques. He will give insight on the evidential perspective and how the evidence is not sufficient enough to prove Becker guilty. Van Owen even found video footage that displays a strong motive to kill Brackman, but not by Avery. However, the imposing investigators did not even bother to put this in the investigation of the crime scene and evidence, which left this and other material out. The opposition, including Detective Markowitz, had clear access to this information, but it did not include it as it did not fit their narrative. Van Owen will then move forward to disprove the cell phone theory evidence, as Avery's cell phone was left at the Fry Shack restaurant and could have been taken or stolen. Avery was at the mall that day and had not dared to go near Brackman's house. So how could have Avery possibly been at this location and be at the mall backtracking at the same time? She can't. It's not plausible. Next, you will hear from Taylor Perkins. Taylor is most relevant as she will offer an alibi for Avery Becker. Taylor Perkins is the best friend of Avery Becker, who now attends BU Boulder. Taylor was on the mock trial team with Avery and views her highly. She will go on to explain how Avery Becker was unjustly kicked off the mock trial team, which was of utmost importance to her. We'll also hear a lot about the main rival, Alex Cifuentes, who is not fond of Avery and despises her very much so. Perkins will then speak about how Cifuentes is highly suspect to conspiracy with Blair Rowland, a student who hated the mock trial coach after losing his dad's court case. That, Your Honor, is more of a motive to kill someone. In addition, Taylor will inform us about how Avery Becker had left her phone at a popular restaurant, as stated before, when the mock trial team was there, including Alex and Blair. This paved way for the pair to steal Avery's phone, come up with fake text messages for the murder, and thus frame Avery. This is possible, but even so, the other side didn't include this information. Finally, you will hear from Avery Becker herself, who will admit to being recognized as the best attorney on the mock trial team, earning multiple awards at regional tournaments. Of course, as we established with the two trees, success and recognition will always draw bitterness. Cifuentes will then truly show hate and bitterness, making Avery Becker out to be a monster to appeal to the court. What Alex does not realize is that he ultimately reaps what sow. His lies will come tumbling down upon her, proving that the stories were fabricated. Ladies and gentlemen of the jury, do not let the opposition manipulate your ruling. When we draw near the end of this case, the defense will plead that you find Avery Becker innocent and not as the old hag that she is made out to be. Declaring Becker's guiltiness will ruin her life and dismiss her testimony. Do not let this turn into a conviction and slaughter of another innocent life. Fight for truth, fight for justice, and clear Avery Becker's name. Thank you.
Okay, prosecution, please call your first witness.
Your Honor, I call Detective Jordan Markowitz to the stand.
Please
Good
proceed.
afternoon, Detective Markowitz.
Good afternoon.
What is your occupation?
I am a homicide detective with the Denver Police Department, and I have specialized training and experience with cell phones.
Now, how long have you been in this position?
I've been with the Denver Police Department for 13 years, and I've been a detective for 7.
What about your experience in this field?
I have a cell phone data and technology certification from the American Academy of Law Enforcement.
What about in terms of a courtroom setting?
I've obtained data in over 50 court cases.
Your Honor, I move to admit the detective as an expert in the fields of crime scene investigation and cell phone forensics.
Crime scene investigation and cell phone forensics?
Yes.
Okay, any objection by the defense?
Yes, Your Honor, a brief voir dire.
You may.
All right, thank you, Your Honor. So, Detective Markowitz, my name is Emily Bell. I'll be conducting your voir dire and your cross at a later time. So let's just jump right into it, shall we? So, as you have been with the Denver Police Department for 13 years, wouldn't you agree that time reflects expertise?
Could you repeat that? I cut out for a sec.
Yeah, no worries. So, as you have been with the police department for 13 years, wouldn't you agree that time reflects expertise?
Of course, yes.
So therefore, if time reflects expertise, you would agree then that a 3-day program is not surely enough to classify yourself as an expert in cell phone data analysis?
As time reflects expertise, I've been with the Denver Police Department for 13 years, so I believe that experience is enough.
So then you would agree that everyone in court today should value expertise relating to topics as a homicide detective over topics relating to cell phone data analysis?
That does not negate my cell phone data analysis experience. I've obtained data in over 50 court cases.
But we should still value your 13 years with the Denver Police Department the same as a 3-day cell phone intervention detective?
Yes, as well as my actual experience with the court cases obtaining cell phone data records.
All right. Your Honor, the defense objects to Detective Markowitz being admitted as an expert as in cell phone data tower analysis, as she only had a 3-day training and therefore is enough education to surely classify herself as an expert in such field. Thank you.
Response?
Your Honor, under Rule 702, it only requires that an expert has either experience or education, which Detective Jordan Markowitz has plenty of experience in her fields.
Any reply to that?
Your Honor, the defense stand with their previous statement. A 3-day cell phone intervention isn't enough to value herself as a cell phone data analysis expert, and as she is also being regarded as an expert in topics relating to a homicide detective in which she has 13 years of experience.
The objection is overruled, and this witness is found to be qualified through primarily education and training, and experience in the fields of crime scene investigation and cell phone forensics, and may testify on those topics in the form of opinions.
Thank you, Your Honor.
Please proceed.
Let's move on to the day you visited the crime scene. Could you describe what you first saw?
Yeah, so when I arrived on the crime scene, I noticed on the front door there was a Ring doorbell. Then I walked around to the back of the house and noticed the victim, Mackenzie Brackman, was on the floor with a stab wound in his back.
Then what about when you moved on into the house?
So I entered into the house and walked around. I didn't notice any valuables missing. I walked into the kitchen and noticed there was a knife drawer opened, and I noticed there was a knife block that had one missing knife from the knife slot. Then I walked around to the dining room where I noticed there was a broken plate.
Detective Markowitz, may you please turn your attention to a photograph marked Exhibit 1.
Yes.
And we also ask that it be screen shared. Thank you. Do you recognize this photograph?
Yes.
What's being shown in this photograph?
In this picture, we see the victim, Mackenzie Brackman, dead on the floor in the back entrance of the home.
Does this fairly and accurately depict what you saw that day at the crime scene?
Yes.
Thank you, Your Honor. I move to admit Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. Objection to a lack of foundation.
Response?
May I just ask that opposing counsel elaborates on their objection?
Yes, Your Honor. So, yes, Councilman. So we object to this exhibit being admitted into evidence because not sufficient foundation has been laid. We don't know the time and date this photograph was taken, or if Detective Markowitz can testify to if it has been altered in any way, and therefore insufficient foundation has been laid.
Reply?
Well, Your Honor, as these are photos that Markowitz takes for her business, it can be seen as just like her own business records. She keeps them very carefully placed. They're very valuable to her profession, and therefore there's no way that such item could be tampered with.
Your Honor, may I respond?
The objection is overruled. Exhibit 1 is admitted into evidence for all purposes.
Next, Detective Markowitz, may you please turn your attention to an photograph marked as Exhibit 5.
Yes.
Do you recognize this photograph?
Yes, this is the bloody knife I saw upon entering the crime scene.
Does this fairly and accurately depict what the knife was like as you entered the crime scene?
Yes.
Next, may you turn your attention to an exhibit marked Exhibit 7.
Yes.
Do you recognize this photograph?
Yes, this is the open knife drawer as I found it on the crime scene.
Does this fairly and accurately depict the condition the knife drawer was in as you entered the crime scene?
Yes.
Finally, please turn your attention to a photograph marked Exhibit 9. Do you recognize this photograph?
Yes, this is the broken plate as I found it upon entering the crime scene.
And does this fairly and accurately depict how the broken plate was when you first entered?
Yes.
Your Honor, I move to admit Exhibits 7, 5, and 9 into evidence.
Okay, let's take these one at a time. Is there any objection to Exhibit 5?
Opposing counsel, could you please scroll up to Exhibit 5? Thank you. Yes, Your Honor, we object to hearsay and a lack of foundation towards Exhibit 5 being admitted into evidence.
Response?
Your Honor, may you ask opposing counsel to elaborate on the hearsay objection?
Would you do that, please?
Yes, of course, Your Honor. So this is an out-of-court document, so therefore it does pertain to hearsay. And if I could elaborate on my lack of foundation, there was not enough questions nor sufficient foundation laid for this evidence for Exhibit 5 to be admitted into evidence, Your Honor.
Well, first, addressing the hearsay, as I mentioned before, Detective Markowitz takes these pictures for her business. You can call them business records. So therefore, under that rule, this picture is not hearsay. Regarding the lack of foundation, Your Honor, may I please lay some more foundation to this exhibit?
Yes, I would like you to lay some more foundation for both of those objections, both the exception to the hearsay rule and the lack of foundation.
Thank you, Your Honor. Detective Markowitz, what's your job again?
I'm a detective with the Denver Police Department.
And what do these pictures mean to you?
I take pictures for crime scene investigation upon entering any crime scene I go to.
So it is your business to take these pictures?
Yes.
Where are these pictures secured? Are they tampered with at all?
No, they're not tampered with.
Your Honor, I believe this provides sufficient foundation regarding the hearsay claim.
Well, let's take that one. Any reply to that response regarding business records?
Sorry. Yes, Your Honor, we still object because Detective Markowitz did not take these photographs. Rather, she reviewed them as part of her investigation. So therefore, it doesn't have first-hand account, and we still stand by our hearsay objection as no other foundation has been laid against it.
Okay. Now let's talk about lack of foundation.
Yes. Your Honor, may I please lay some more foundation regarding this picture?
Yes.
Detective Markowitz, do you recognize this photograph?
Yes.
What's being shown here in this photograph?
We see the knife that was used to murder the victim as it was found in the crime scene. Sorry.
Does this fairly and accurately describe the knife's condition when you entered the crime scene?
Yes, this is how it was found.
Thank you.
Response to that testimony.
Yes, Your Honor, it still has not been established what Detective Markowitz's relationship is like with this photograph. So if the opposing counsel could just have one more question, that would be wonderful. Thank you.
Your Honor, just for efficacy, we shall just move on and not admit Exhibit 5 into evidence.
Okay, Exhibit 5 is withdrawn.
And as well as 7 and 9, just for efficacy's sake.
Okay, all three of these exhibits, 5, 7, and 9, are withdrawn and are not to be considered at this point for any purposes in this proceeding.
Thank you, Your Honor.
Next, you mentioned a Ring doorbell.
Yes.
Can you describe why you thought this was important?
In the Ring videos, we see a hooded figure approach the front door. Then in the second video, we see the figure walk around the side of the house. In the third video, we see the figure entering the back door. And finally, a few minutes later, in the last video, we see the figure rushing out of the front door of the house.
Detective Markowitz, may you please turn your attention to Exhibit 12?
Yes.
Detective, do you recognize this video?
Yes.
What's being shown in this video?
In that video, we see the hooded masked figure entering the back door of the house.
Finally, does this fairly and accurately describe what the Ring videos portray to you?
Yes.
Your Honor, I move to admit Exhibit 12 into evidence.
Response?
Yes, Your Honor, we object to hearsay.
Your Honor, this in and of itself is not a statement, so it cannot be considered hearsay.
May I respond, Your Honor?
You may.
So as moving these exhibits into evidence is being claimed that they are asserted for the truth of the matter. And therefore, because Detective Markowitz does not have a first-hand account because she didn't take these videos, and because she only has a second-person account of these as she downloaded them, she cannot accurately testify to, you know, the authenticity of these documents, and therefore it is hearsay.
Sorry, could you please repeat that? I had trouble hearing you.
Yeah, of course, no problem. What part did you miss?
Could you just start over for the beginning?
Yeah, of course. So, Your Honor, we object to hearsay because these are both ordered out of court and they may not be documents, but they're still being offered for the truth of the matter asserted. So they are out of court accounts being brought in for the truth of the matter asserted. And because Detective Markowitz did not take these videos, and because she only has a second-hand account of her relationship with these videos, she cannot accurately testify to the authenticity of these videos. And therefore, we object to hearsay.
Your Honor, as an expert as being a crime scene investigator, she has a lot of experience regarding these matters in any case, such as Ring videos, just other things. So therefore, she is more than qualified to testify on such topics.
May I respond, Your Honor?
You may.
So downloading content from the victim's cell phone was not actually tied into her validation as an expertise, and therefore this lies outside her expertise, so she cannot testify to them.
I will sustain the objection based on hearsay at this point, but I will give counsel an opportunity to lay a further foundation as to what exception to hearsay or whether this is not hearsay at all through this witness. So you may proceed in that regard if you wish. Otherwise, the objection shall be sustained.
Your Honor, for efficacy, let's just move on. Next.
Say, Exhibit 12 will be withdrawn and shall not be considered for any purpose in this proceeding. Please proceed.
Next. Jordan Markowitz, please turn your attention to Exhibit 13.
Yes.
Detective, do you recognize this video?
Yes.
What's being shown in this video?
In this video, we see the hooded figure from earlier rushing out of the house.
Thank you. Let's just move on then. No need to admit that. Next, when you were investigating Brackman's body, what did you find?
On his body, I found his cell phone.
What did you do with this cell phone?
With his cell phone, I was looking through it and I noticed he was a lawyer and that I knew him. Furthermore, I continued to look into his phone and found he spent a lot of time as a mock trial coach. So naturally, I followed that lead as that's where he seemed to spend most of his time.
Regarding mock trial, what did you find out?
I reached out to the school and was able to obtain the numbers, the cell phone numbers for all the students on the team to reach out to them.
Did you contact any of them?
I reached out to Alex Cifuentes first.
How did Cifuentes help?
Cifuentes provided me with text messages from another suspect named Avery Becker.
Did you manage to get his phone?
I was not able to get Alex Cifuentes' phone, but I was able to receive screenshots after our meeting.
Why did you need these texts?
These texts show Avery and Alex's interactions regarding Avery's angry sentiment towards Brackman.
What did Avery say in these texts exactly?
Becker had texted.
Objection, speculation. The Detective Markowitz is testifying to evidence not being admitted in court, and also testifying to something that she cannot actually testify because Exhibit 14 and 15 have not been admitted into evidence, so therefore speculation.
Response?
Your Honor, under Rule 703, an expert may testify and share their opinion on evidence that hasn't been admitted yet.
Your Honor, may I reply?
You may.
That rule only applies to something that's not being offered for the truth of the matter asserted, and because Detective Markowitz is testifying to evidence, that is an exception to the rule. So therefore, my speculation still stands.
Reply?
Your Honor, permission to confer with co-counsel.
You may.
Your Honor, should the other prosecution attorneys turn their videos on to confer with our co-counsel?
Well, you probably don't want to communicate and have the rest of us hear it.
Yeah, well, you guys can just do the chat. Pull up in the chat the individual person you want to talk to.
Okay, thank you, Your Honor.
All right, Your Honor. Once again, I cite back to Rule 703. It's solely saying that Detective Markowitz is able to make opinions on evidence that hasn't been admitted because of her expert testimony in these fields.
May I respond, Your Honor?
You may.
The testimony that Detective Markowitz is offering is not an opinion, but rather rather fact offered being offered for the truth of the matter asserted. And
Your Honor, this evidence is solely used to explain Detective Markowitz's further intents and further decisions regarding this case, explaining why she followed the leads that she did and why she thought it was important to follow the leads of Avery Becker.
may I respond, Your Honor?
Okay, I'm going to, well, I need a formal offer of the exhibit that we're discussing here. So why don't we go there and then we'll talk about whether it actually gets admitted. So why don't you pull up the exhibit and make a formal offer?
Your Honor, we don't seek to admit this evidence. We solely just wish to talk upon it. If you still want us to pull it up, we can, but.
Yes, please do.
All right.
Okay, now go ahead and ask some foundational questions regarding this exhibit. Counsel?
Yes. So do you recognize these text messages?
Yes, these are the screenshots that Alex was able to send me of Alex and Avery's interactions.
And what's being said in these text messages?
If you read the text yourself, basically, Becker had texted Cifuentes pleading for help to get him back onto the team. He also threatened to trash Brackman's house. So this led me to look into Becker's phone records.
Your Honor, is that sufficient foundation regarding these text messages?
Well, you tell me.
Well, I believe it is, as we are not seeking to admit it, solely just looking for the detectives to speak upon it.
Well, I'm going to sustain the objection of having this witness, based on what I've heard, testify as to essentially the contents of this exhibit without it being admitted. So I will sustain that much of the objection at this point. But again, I'll give you, counsel, the opportunity to have the exhibit admitted if you want its substance to be presented to the jury.
No, thank you, Your Honor. We shall just continue.
Okay, please do so.
What did you do after looking at these texts?
I was prompted to look at Avery Becker's phone records. I reached out to Avery Becker for comment, but I was stopped by their lawyers. So I obtained their phone number and looked into their call detail records.
What did you find using these phone records?
So call detail records, just for some background, they connect the phone to the nearest tower with every call or text interaction. And using these CDRs, I found the cellular location of Becker's phone in the hours leading up.
Objection, narrative.
I'm sorry, what was the objection?
Narrative. Can I elaborate on my? Okay, thank you.
Please proceed.
All right. Can you explain why you needed these call detail records?
So these call detail records show a clear route from Becker's house to Brackman's house in the hour leading up to his death. We see between 12:45 and 12:55, Becker receives a text that connects them to the tower nearest their house. Then in between 12:55 and 1:05, the phone is connected to the tower in between Becker and Brackman's house. And finally, in between 1:05 and 1:17 that day, the CDRs place Becker's phone to connect it to the tower nearest to Brackman's house.
Thank you. May you please turn your attention to Exhibit 16?
Yes.
Do you recognize this picture?
Yes.
What's being shown in this picture?
This is the most logical route from Becker's house to Brackman's house using the CDR locations.
Could you explain what these red arcs and the blue dotted line are?
The blue dotted line is, again, the most logical route. And the red arcs is the area in which the cell tower covers.
Does this fairly and accurately depict both the arcs of the cell towers as well as the route you're seeking to convey?
Yes.
Your Honor, I move to admit Exhibit 16 into evidence.
Response?
This is hearsay. It is an out-of-court document being offered for the truth of the matter asserted.
Your Honor, once again, as this is part of Detective Markowitz's job, this is a record she keeps for her business, and therefore it is not hearsay.
Reply?
We stand by our hearsay objection as it is being offered for the truth of the matter asserted and is an out-of-court document.
The objection is overruled. There has been enough foundation laid to bring this in to the business records exception to the hearsay rule.
Thank
So
you, Your Honor.
exhibit 16 is admitted for all purposes. Please proceed.
Thank you, Your Honor. Next, using your expertise, do you have a final opinion?
Using the culmination of kind of everything we've seen today, including the route and the CDR locations, Avery's guilty without a reasonable doubt.
Thank you, Your Honor. No further questions.
Cross-examination, please.
Yes, Your Honor. Alrighty. So, good evening, Detective Markowitz. My name is still Emily Bell, and I will be crossing you today. This is a short reminder, but I do ask you to keep your answers to the shortest length possible. Yes or no will suffice. All right, let's begin. So I'm going to start with your investigation. You arrived and saw the front door open, correct?
Yes.
And then you then observed the victim and the murder weapon, yes?
Yes.
And you state that the victim had, quote, most likely fallen to the ground while trying to leave the residence, correct?
Yes, we see the stab wound in his back, and he was lying face down on the ground.
But are you not completely sure, detective, as you stated most likely instead of definitely?
As I was not there as the murder took place, I have to rely on what I most likely thought happened, so yes.
All right, thank you. And you then turned and saw the residence in disarray, correct?
Yes, there was a broken plate, the drawer was opened, and the knife block was missing a knife.
All right, thank you, detective. Once again, I do remind you that a yes or no will suffice for these questions. But you couldn't tell if the residence in disarray was a result of a struggle, correct?
Correct.
Now I'd like to turn your attention to Mr. Brockman. You knew Mr. Brockman before this investigation, correct?
I did, yes.
In fact, you would agree that you and Mr. Brockman did not have a positive relationship, correct?
Objection, Your Honor. Relevancy.
Your Honor, I'm trying to show any potential bias that this witness may have towards the victim, and they could also influence the further findings of this investigation.
Essentially, it's credibility that you're
Yes,
going
Your
for? Okay, thank you. Response to that?
No, Your Honor. No, Your Honor.
Okay. Objection is overruled.
Thank you, Your Honor. I'll move on. I'll continue my questions. Would you like me to repeat the question, Detective Markowitz?
Yes, please.
All right. So you and Mr. Brockman didn't have a positive relationship outside of You and Ms. Brockman didn't have a positive relationship, correct?
Let me elaborate. I met him on opposite sides of the courtroom a few times, and I realized that he did like to take cheap shots at the police department where I worked, but he was a good lawyer at the end of the day.
But these cheap shots that he took at you tended to offend you, correct? As a homicide detective for 13 years.
I
Yes or
wouldn't
no,
say
will suffice.
I wouldn't say they offended me. I just said I disliked them.
Okay, thank you. I will continue. So, in fact, you stated that his occupation as a criminal defense lawyer brought him disgruntled ex-clients, correct?
Correct, yes.
And you stated that it was, in fact, an implied lead for this case, yes?
Yes, yes.
And did you follow up on this?
I did
Yes
not.
or no will suffice.
Let me elaborate, please. I did think it could have been a disgruntled ex-client, but after looking into mock trial, I realized that was the more logical lead, considering he spent most of his time doing mock trial.
But you didn't interview any of Mr. Brockman's ex-clients, correct?
No, mock trial was the clear lead.
And wouldn't you agree that good police work requires one to follow up on all leads?
Yes.
So instead of interviewing any of Mr. Brockman's ex-clients, you interviewed teenagers, specifically Mr. Solfentes on the team he coached, correct?
Objection, Your Honor. Compound question.
Your Honor, this is not a compound question. I just stumbled over the word specifically for quite a little bit.
Okay, would you repeat the question, please?
Yes. So instead of interviewing any of Mr. Brockman's ex-clients, you interviewed teenagers, specifically Mr. Solfentes on the team he coached, correct?
Yes, he spent most of his time doing mock trials, so that would make sense.
And from that interview, Ms. Solfentes offered up incriminating text messages towards Ms. Becker, correct?
Yes.
Your Honor, would you like me to show the exhibit I'm referring to for this? I'm not asking about the content of it. However, I'm talking about the path it took for Detective Markowitz to obtain them.
Well, go ahead and do, pursue your line of questioning as you wish. And if opposing counsel has objections to it, I will hear them and rule on them. But you go ahead, you do what you feel you should do.
Okay. Thank you, Your Honor.
In your questioning.
Thank you. So, and from that interview, I'll repeat my question just to establish foundation. So from that interview, Ms. Solfentes offered up incriminating text messages towards Ms. Becker, correct?
Yes.
Now, did Mr. Solfentes have his cell phone on him at the time?
No.
And did he get the screenshots of the text directly from Mr. Solfentes' cell phone?
Yes.
They were sent to you from Mr. Solfentes, correct?
Yes.
And do you have the photos in front of you? So this is when I am referring to the contents of it. So would you like me to pull up the exhibit?
Yes, please.
All right. Thank you, Your Honor. I will indeed do that. Oh, I don't know how to do this. Okay. Hold on one second. I apologize for the wait, Your Honor. Okay, so I am not able to share them just because of the settings I have on my computer at this time. Timekeeper Slavin, could you possibly pull them up? Okay.
If you would like, I can do it.
Oh, please, that would be wonderful. Thank you.
It's exhibit 14 that we were talking about.
Correct. Okay, awesome. Thank you. So I would like to turn your attention to exhibit 14, which is in front of you at this time. So, excuse me. Now, there aren't any cell phone numbers indicated on these text messages, correct?
No.
And there isn't a time on when these texts were sent, correct?
No.
And there isn't a date on when these texts were sent, correct?
No.
All right, that is all I need for those. Thank you. I really appreciate it. Okay.
Anytime.
And so did you follow up and obtain Mr. Solfente's cell phone to verify the authenticity of these text messages?
No, I did not.
So sitting here today, you cannot testify that those text messages are authentic, correct?
No, I did receive the screenshots, but I cannot
All right,
testify
and
that
just
they're authentic.
for clarification of the jury, Detective Markowitz, you cannot confirm that Ms. Becker sent those text messages to Mr. Solfentes, correct?
No, but I feel like it would be unlikely that any other situation would have happened.
All right. Once again, I do remind you that yes or no will suffice to my questions. All right, now I'd like to move on to your investigation of Ms. Becker. So Ms. Becker lost her cell phone on March 5th, 2020, correct?
That's what she says, yes.
And this is before the murder, correct?
Yes.
Did you ever locate Ms. Becker's cell phone?
Yes, I did through the CDRs.
But did you ever locate her physical cell phone, ma'am?
No.
And yet you stated that you assumed the cell phone was probably destroyed after the murder, correct?
Correct.
Do you have any evidence of this?
No.
And did you ever investigate this?
No, it doesn't matter if the cell phone was destroyed or it turned off or any other situation that happened to the cell phone doesn't negate any of the previous CDRs that had been recorded.
But if Ms. Becker did not have her phone, would the authenticity of Ms. Becker's assumed location would be reflected on the CDRs? I can repeat the question if you would like.
Yes, please.
So, yeah, of course. So, but if Ms. Becker had lost her cell phone, would her location portrayed on the CDRs even matter? As it only pertains to where her cell phone is, not where she was?
I guess not, but teenagers always have their phones.
All right, thank you. And moving on, you stated that it was clear Ms. Becker went to Mr. Brockman's house, correct?
Yes.
And do you have any evidence saying or testifying that Ms. Becker even knew where Mr. Brockman lived?
That's not in my witness statement. Would you like me to respond?
As a part of the investigation, it is required that you follow up on any potential leads, and testifying to if Ms. Becker knew where Mr. Brockman lived is part of your investigation. So even though it's not implicitly stated, it can be inferred. Would you like me to repeat the question?
Yes, please.
Do you have any evidence saying that Ms. Becker even knew where Mr. Brockman lived?
No, but that's not my witness statement, so.
Okay, and just one final question. So you would agree that lack of proper interviews of the disgruntled ex-clients for clarification of the jury and lack of investigation on the cell phone and matters pertaining to the cell phone show that you neglected some aspects of this case, correct?
Because Alex Cifuentes was such a strong lead, I believed it wasn't necessary for me to follow up on the disgruntled ex-client. It's really fortunate that the case was so linear and that the leads proved so efficient, for lack of a better word.
A yes or no will suffice my questions. So the lack of interviews pertaining to any other mock trial students and investigation pertaining to the cell phone show that you neglected some aspects of this case, correct?
Yes.
All right, thank you. No further questions.
Any redirect for this witness?
No, Your Honor.
All right, thank you. Prosecution, please call your next witness.
The prosecution calls Ms. Kyle Cusack to the stand.
Please proceed.
May you please state your name for the court record?
My name is Kyle Cusack.
And what is your occupation?
I am a civilian employee of the Colorado Bureau of Investigations, and I do my work at the Colorado Bureau of Investigations as a crime scene reconstruction investigator.
And what qualifications do you have in crime scene reconstruction work?
I am certified by the City of Denver and the Colorado Bureau of Investigations. I have 19 years of experience, the last three of which have been with a tenure with Denver, and I specialize in complex crime scenes.
And generally speaking, how do you go about reconstructing a crime scene?
I follow a 5-step process. The first step is recognition and documentation. The second step is collection of evidence. The third step is evaluation of evidence. The fourth step is hypothesis and testing. And the fifth step is reconstruction.
Your Honor, I move to admit Ms. Kyle Cusack as an expert in crime scene reconstruction.
Any objection?
No objection, Your Honor.
This witness shall be deemed qualified as an expert in crime scene reconstruction and may testify with respect to that area through opinion evidence pursuant to Rule 702. Please proceed.
Thank you, Your Honor. Ms. Cusack, when did you arrive at the crime scene?
I first arrived at the crime scene after it was processed by the police department.
And what were your first steps in reconstructing this particular crime scene?
This particular crime scene, I started with recognition and documentation. In doing so, I created a witness tracking sheet, an evidence tracking sheet, and a rudimentary flowchart.
Ms. Cusack, if you could please turn your attention to Exhibit 17 and let the record show that I'm requesting that my timekeeper screen share a copy of Exhibit 17. Ms. Cusack, when did you create this document?
I began creating these 3 documents when I first arrived at the crime scene.
Your Honor, I move to admit Exhibit 17 into evidence.
Response?
Objection, Your Honor, hearsay. Objection, Your Honor, hearsay.
Reply?
This exhibit falls under the exception for hearsay 8036. It is a business record that is kept in accordance with the regular activity of Ms. Cusack's business, and she created it around the time that she arrived at the crime scene.
Response?
Objection is to hearsay because it's an out of court document.
Well, the contention is that this is an exception to hearsay under the business records provisions. Could you address that, please? You're muted.
I said no response, Your Honor.
All right. Objection is overruled. Exhibit 17 shall be admitted into evidence for all purposes.
I would request that my timekeeper screen share the document.
Sorry about that.
And may you please turn to the 3rd page of this, which would be the flowchart. Thank you very much. Now, Ms. Cusack, can you please explain to the jury what this flowchart shows?
Of course, this flowchart I created as a visual representation to allow me to help explain how the crime occurred. As we see on the flowchart and in Ring videos, the perpetrator first approaches the house and attempts to enter through the front door. His intentions appear to be breaking and entering, at least, if not some other form of criminal mischief. Finding the front door locked, he goes around the side and then approaches the back door. After finding the back door unlocked, we know he enters.
Objection, Your Honor, narrative.
Response?
Your Honor, the witness requires time enough to explain the entirety of the flow chart.
Reply?
Your Honor, I'm just asking if the counselor can break up the question to make it easier for the jury to understand.
Well, at this point, the objection will be overruled. The narrative is not excessive, and it is, it's more than just background, but I will allow this line of questioning and that line of answering. So please proceed.
Thank you, Your Honor.
Okay, after the perpetrator enters the back door, there are two possibilities. Either the victim was alerted to the perpetrator's presence outside and around his home from the multiple notifications he would have received from his security system and doorbell, the Ring. If that is okay. If that is not the case, then the victim was alerted to the perpetrator's presence in his home from the opening of the back door, which is very loud. From there, the victim, either way, having been alerted, went to receive a knife from his kitchen and then met the perpetrator in the back room. The scuffle then occurred in the back room near the door and moved through the house and into the front area where the perpetrator ended up with the knife that the victim brought into the encounter, and the perpetrator was able to stab the victim in his upper back shoulder, which ended up killing him when the victim pulled the knife out. Upon having stabbed the victim, the perpetrator runs out the front door and the victim pulls the knife out of his own back and bleeds out on his floor.
And why do you think that the victim being alerted via the Ring doorbell is the most likely scenario?
This is the most likely scenario because the Ring doorbell acts as a security system, and anytime the cameras track movement, the Ring doorbell system will send a notification to the linked phone. That means that the victim got at least 2, if not 3 to 4 notifications from the Ring doorbell system. Furthermore, the Ring offers a live video feed for him to check at the moment, and even if that is not true, my conclusions leave open the opportunity for the victim to have heard the door open and went to arm himself then, which is more likely than the defense expert's opinion, than the defense expert's final conclusions.
Similarly, how do you know that the knife came from inside the house?
The knife came from inside the house because there is a missing knife in the knife block that matches the knife, a large chef's knife. If not, then there is also a drawer full of miscellaneous knives that are around the same size as the knife that was used to kill the victim.
And can you please describe to us what the perpetrator was like physically speaking?
Yes, the perpetrator, physically speaking, had a similar build and height to the defendant.
And lastly, why did you conclude that the perpetrator went to the residence with the intent to commit some form of criminal mischief?
The perpetrator, when he approached the property, approached in dark clothes and was wearing a mask. He then attempted to open a locked door and, having found it locked, went around the side and attempted to find another entrance. Furthermore, we never once see a knife in any of the Ring videos, and the clothing the perpetrator is wearing does not appear to be able to hide a knife in it. And if the perpetrator was entering the house and met the victim when the victim was carrying a knife, a scuffle would have occurred, which would have killed the victim. The perpetrator never acted as though he had any intention to kill someone.
Thank you, Ms. Cusack. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Mrs. Cusick. My name is Cecina Abraha, and I will be conducting your examination today. Please refrain from expanding your answers beyond a yes or no. You're not a police officer, correct?
Correct. I'm a civilian employee of the Colorado Bureau of Investigation.
Therefore, you do not have the credentials of a police officer, correct?
No, I have the credentials necessary to be a CSR.
Okay, thank you. Let's move on to what you claim to be evidence. One of the forms of supposed evidence in your affidavit is scuff marks, correct?
Yes,
You state that the scuff marks resulted from a struggle.
I do.
Isn't it possible that the scuff marks could have been there prior to the incident?
I would say no. As far as the power and speed required to create scuff marks, especially 6 in such close proximity, would require a large amount of force and speed. Furthermore, that we see a mat outside that a person could have wiped their foot on, and there is a rug very close to the scuff marks indoors. Either way, the scuff marks appear to only have occurred unintentionally from a scuffle.
Okay, please keep your answers within the frame of yes or no. So you're saying that it is not possible for any of the scuff marks to have been there prior to the incident?
Objection, Your Honor, asked and answered.
Okay.
Response?
I'll move on.
Sustained.
Okay. Isn't it true that you cannot carbon date scuff marks?
It is true, you cannot. But as I previously just said, it is unlikely that they were created previously.
Okay, thank you. Therefore, isn't it true that the scuff marks might not have been there from the incident?
Objection, Your Honor, asked and answered.
Response?
I'll move on.
Sustained.
Wouldn't you agree that the scuff marks, that you cannot surely and definitely state that the scuff marks, sorry, let me rephrase the question. So then wouldn't you agree with me that you cannot surely and definitely state that a struggle happened?
I would say that the most likely conclusion for how this crime occurred is that a scuffle occurred. That is the only way to explain why the victim's knife ended up in his own back from the perpetrator.
Okay. But can you surely and definitely state that a struggle happened?
Objection, Your Honor, asked and answered.
Response?
The witness did not answer my question completely.
Objections overruled. Please re-ask the question.
So you can surely and definitely state that a struggle happened in this kitchen, in the witness home?
I cannot surely state anything. However, due to CSR work being based on the evidence and then making the most logical conclusions from that evidence, I would say the most logical conclusion is that a scuffle occurred, yes.
Okay, thank you. Let's move on to the murder weapon. The murder weapon in this case was a knife, correct?
Yes.
And this knife was found on the floor beside the victim, correct?
Yes, covered in blood, the victim's blood.
Okay, thank you. Isn't it also true that you assumed that the knife came from the victim's knife block?
As I just stated, CSR work is entirely based on looking at the evidence and finding the most likely conclusion. Considering we never see the perpetrator carrying a knife in any of the videos, the most likely conclusion is that the knife came from inside the home.
Please answer with a yes or a no.
I just answered that question. Would you please re-ask it and I will answer again?
Okay, thank you. The murder weapon doesn't match any of the knives in the victim's knife block, though, does it?
It is the same type of knife as the knife that is missing from the knife block, a large kitchen knife, chef's knife.
Okay. Can you be sure that the knife missing from the knife block is the same knife that was used to stab the victim?
I'm sorry, you cut out for me. Can you please ask that again?
Sorry. Can you be sure that the knife missing from the knife block is the same knife that was used to stab the victim?
I can assure that the knife that was used to stab the victim came from inside the house.
Okay. Isn't it possible that the murder weapon could have come from somewhere else?
It is possible, though, as I stated already, unlikely, more likely than not, the knife came from inside the house.
But isn't it possible for the murder weapon to have been taken from somewhere outside of the residence?
I'm sorry, you keep cutting out. Say that again.
Isn't it possible for the murder weapon to have been taken from somewhere outside of the residence?
It is possible, but though, as I've already stated, we never see the perpetrator in any of the ring videos carrying a knife.
So then wouldn't you agree that you cannot surely state where the murder weapon came from?
As I've already stated, in CSR work, I can never truly guarantee anything. I was not there for this crime, and therefore I do not know to a 100% degree. I would say the most likely conclusion is that the knife came from inside the house, not with the perpetrator when he entered.
Okay, I'm now going to be moving on to your contributions to this case. You have Exhibit 17 in front of you.
I do.
I ask that my timekeeper screen share Exhibit 17. I would like to turn your attention to the names on this document. You documented that there were 3 suspects, correct?
Yes, I do.
And 3 suspects you documented were Avery Becker, Alex Fuentes, and Blair Rollins, correct?
Yes.
Yet also in your report, you stated that the police were unable to locate Mr. Rollins.
I do.
Furthermore, you established that Mr. Cifuentes knew Mr. Rollins, correct?
Yes.
In your witness tracking sheet, you were also not able to establish the extent of their relationship, correct?
No, but I was capable of establishing the fact that Blair Rollins knew all 3 of the suspects, or all the 2 suspects, Alex Cifuentes, Avery Becker, as well as the other defense witness, Taylor Perkins.
Okay, please answer with a yes or no. So then we agree that it is indeed possible for collaboration between Mr. Rollins and Mr. Cifuentes?
I'm sorry, please repeat the question, you cut out again.
So then wouldn't you agree that it is indeed possible for a collaboration between Mr. Cifuentes and Mr. Rollins?
It is not my job to decide whether or not the a suspect was able to collaborate with another. My job is to recreate the crime.
Okay, no further questions, Your Honor.
Any redirect?
No, Your Honor.
Okay, thank you. Defense, or sorry. Please call your next witness.
Your Honor, the prosecution would like to call its next witness, Alex Fuentes, to the stand. Good afternoon, Mr. Fuentes.
Hello,
Can you please state your name for the record?
my name is Alex Cifuentes.
And can you please introduce yourself to the jury?
Hello, everyone. Once again, my name is Alex Cifuentes. I am a current senior at CHS as well as on the A team of mock trial.
Mr. Fuentes, I'd like to talk a little bit about Mackenzie Brackman. Did you know Mackenzie Brackman?
Yes, I did. He was our amazing coach.
And how long was he your coach for?
He was my coach for the entirety I was on A team.
And how would you describe your overall relationship with Coach Brackman?
I really respected him. He was not only an amazing litigator, he was an amazing coach, and he was always there for us.
Thank you. Let's shift to your relationship with the defendant. Do you know Avery Becker?
Yes, I do.
And how do you know her?
Avery and I are best friends. She's actually one of the reasons why I joined mock trial in the first place. She and I definitely made the team great, even though we had differences in work style.
And did you spend a lot of time in mock trial practices around Avery?
Yes, I did. We definitely worked on mock trial a lot, and mock trial was definitely a big part of my life, so yes.
And how well did Avery perform as a lawyer?
I'll admit she was fairly good as her lawyer role. I mean, she definitely had the ability to make the jury believe whatever she wanted, but she also had the habit of making things up on the fly.
And was Avery Becker on A team the entirety of her senior year?
No, she wasn't. She was actually bumped down to the B team with all the losers once, and then later in the season, she was actually bumped off the team entirely.
And you mentioned that when Avery was demoted to the B team, when did this happen?
This happened a little bit before regionals, but she somehow managed to make it back on the A team.
And from what you could observe, why was she demoted to the B team?
Well, from what I
Objection,
could observe,
relevance.
Your Honor, I'm establishing the fact that Mr. Cifuentes was witness to Avery Becker being demoted from the B team, and this will contribute to Avery Becker's motive. And it will also show that Mr. Cifuentes can testify to how Mr. Brackman reacted to Avery Becker's behavior on mock trial.
Response?
Your Honor, it has been established that Becker was not always on the A team, and sorry, that it has already been established that she was already not on the A team for a while. So I think my mistake. I think I would rather object to asked and answered. My bad.
Okay, response to that.
Your Honor, I have only asked Mr. Cifuentes if Avery was if Avery was demoted to the B team. I have not yet asked Mr. Cifuentes what he observed the reasons were for her demotion to the B team.
Objections overruled. Please proceed.
Mr. Cifuentes, would you like me to repeat the question?
yes, please.
From what you could observe, why was Avery demoted to the B team?
Well, from what I could observe, I mean, Coach Brackman and Avery always had their little bickers. They definitely were different people, and Avery always came unprepared. She was always late to practice. She never had preparations for any of her, say, directs or crosses, and it definitely put the team in a huge state of anxiety. So he did not think that she deserved to be on A team.
And from what you could see, how did Avery react to Coach Brackman's decision to demote her?
From what I could see, she was very humiliated. I mean, B team is full of losers. And the fact that she was being demoted after all of her work the previous 3 years, it was just probably, from my observation, she was very humiliated and frustrated.
And how would you describe Avery and Mr. Brackman's overall interactions on mock trial based on your own observations?
They definitely, once again, had their bickers from time to time. They also had their many feuds, and I would definitely say that the relationship was tainted. And
Objection, asked and answered.
Response?
Your Honor, I do not believe that I have asked for an overall testimony on Avery and Mr. Brackman's overall interactions on mock trial. I've asked about it specifically regarding her demotion to the B team.
Reply?
Your Honor, I think correct me if I'm wrong, but I believe she had previously asked about the relationship between Becker and Brackman about 2 questions ago.
Objection is overruled. Please proceed.
Mr. Cifuentes, what were Avery and Mr. Brackman's overall interactions on mock trial like based on your observations?
Well, once again, they always had their feuds and they had their little disputes. And, you know, I don't think Avery actually respected Coach Brackman. I don't think that she actually put the team first. And, you know, it definitely just did not seem like a really good relationship.
And how often did these hostile interactions occur?
It happens pretty frequently.
Thank you. I'd like to shift now to the practices following the regional tournament. At the practices following regionals, what were Avery and Brackman's interactions like from what you could see?
Well, after regionals, there was actually this really big fight. Actually, the practice right after regionals, and they had just this really huge argument. It was really embarrassing, basically the climax of the entire season.
And how did that fight begin?
Well, since it was after regionals, Avery had actually won some awards from regionals, and Coach Brackman was basically telling her that no, she did not, in fact, deserve those awards. So she was really angry. And
Objection, narrative.
Your
Response?
Your Honor, in order to testify to the entire event which occurred at this practice following regionals, my witness needs to finish his statement, and he has not yet completed describing what he saw that night.
The objection's overruled.
So as I was saying, they got into this huge dispute that night, and after that, Avery did something horrible that night.
And what did Avery do?
Well, we had this eel of Sharpies that we would write down our mock trial ideas on, and so after they got into this heated argument, she ran over to this like eel of Sharpies, and she stormed out of the building. And do you know what she did? She wrote "Worst Attorney Award" on his white Porsche. I mean, who would even do that? She's lucky that he didn't pursue legal action. So after that, he obviously kicked her off the team.
And from what you could observe, how did Avery react to being dismissed from the mock trial team?
From what I could observe, she was very humiliated and furious to be completely dismissed from the team.
And did she ever make any attempts to get back on the team?
Yes, she did. She did, in fact, text me a little after the incident, and she also, I believe, created a meeting with Coach Brackman, and I did try to help her, but it did not pan out.
You mentioned the text between you and Avery. Let the record reflect that I'm asking our timekeeper to please screen share what has previously been marked as Exhibit 14. Mr. Fuentes, can you confirm that these screenshots are of your text exchange with Avery?
Yes, they are.
How do you know that these screenshots are of your text exchange with Avery?
Because I remember sending those texts as well as receiving them.
And have these screenshots been altered in any way?
No, they have not.
Are these screenshots a fair and accurate representation of your text exchange with Avery?
Yes, they are.
Your Honor, the prosecution moves to admit Exhibit 14 into evidence.
Any objection?
Yes, Your Honor. So the text message was on Avery's old phone, or on Alex's old phone, which she admits to not having anymore. So there's no way to confirm the validity or origin of these text messages.
Is your objection hearsay?
Yes.
Or lack of authenticity, or both?
Oh, I'm sorry, Your Honor. What? Breaking up.
Is your objection also lack of authenticity?
Yes.
Okay, two objections: hearsay and authenticity. And please address them one at a time in response.
Yes,
Okay.
Your Honor. As far as the hearsay objection, pursuant to Rule 801D2, this evidence is not hearsay because it contains an opposing party statement, as half the text in the exhibit were made by the defendant. Furthermore, the evidence is also not hearsay because pursuant to Rule 801D1, this is a declarant witness's prior statement. And as far as the authenticity, the defense has not proved with a preponderance of the evidence that these texts are not authentic, and so that goes to the weight, not the admissibility of the evidence.
Respond to those one at a time, please.
Yes, Your Honor. So according to the prosecution, the witness had made this, sorry. So for as far as authenticity, Alex Fuentes had mentioned in his witness statement that he no longer has access to the phone because he traded it in for a new one. So therefore, how are we supposed to know that? How are we supposed to know that these text messages were not altered if there's no way of confirming their origin and no way of confirming that they actually took place?
Objections on both grounds are overruled, and Exhibit 14 is admitted for all purposes.
Thank you, Your Honor. Mr. Cifuentes, what were these texts about?
Well, basically, a little after regionals, Avery was texting me to talk to Coach Brackman about her demotion because she knew how close I was to Coach Brackman. And she was asking if I could help her in any way, and I decided to help her. But when I talked to Coach Brackman, they actually didn't pan out. So I told her that, and she got really upset, saying that she was going to do something to his house. I didn't think she was going to do anything, but I guess she did.
And when did Avery text you regarding these plans?
She texted me a little after the regionals incident.
Thank you, Mr. Fuentes. I'd like to jump forward in time a little bit. When did you find out about Coach Brackman's death?
I found out the day he actually didn't show up to mock trial practice. It was really weird that he wasn't there, and so we just left mock trial practice. And later that night, we did find out that our mock trial coach was dead.
Thank you, Mr. Fuentes. I know this must be hard for you to talk about. Can you please explain the events that unfolded after you had found out about Coach Brackman's death?
Well, after a little bit, I got a call from a Detective Markowitz, I believe, to come down to the station to give a statement, and I brought up the text exchange I had with Avery. And I didn't bring my phone at that point because that battery was the worst, so I sent screenshots in later on.
Thank you. Now, I would like to talk very briefly about Blair Rollins. Do you know who Blair Rollins is?
Yeah, that kid in my grade? Yeah, I do.
And how often do you talk to Blair?
Not very often.
Have you talked to Blair recently?
Can't say I have, no.
Would you ever do any favors for Blair?
Maybe open a door for him, nothing else really.
Thank you, Mr. Fuentes. I have no further questions, Your Honor.
Cross-examination, please.
Yes, Your Honor. Good evening, Mr. Cifuentes. My name is Jacob Vigil, and I will be conducting your cross. Please refrain from unnecessarily elaborating upon your answers. Yes or no will suffice for the majority of my questions. Are you ready to begin?
Yes, I am.
So Ms. Becker was the one who got you to join mock trial, correct?
Yes, she did in fact convince me.
And would you say you would have ever joined for her if she hadn't convinced you?
Probably not. I didn't really give much thought to mock trial beforehand.
And you also state that Avery was basically your best friend, correct?
Yes, she was. We were really close.
However, you would agree that you and Ms. Becker competed quite a bit.
Yes, we did compete a lot of times, yeah.
In fact, weren't there rumors that you and Ms. Becker were rivals?
People may say we were rivals, but I would say we were teammates, and we definitely pushed each other to be better people for the team.
And these rumors conspired out of you and Ms. Becker constantly competing to win Best Attorney Award, correct?
Yes, we definitely pushed each other to be the better person and be the best lawyer we could be.
But didn't you say in your witness statement, lines 7 through 8, that you and Avery had the same level skill set?
I would say we definitely had the same level skill sets, but we definitely had different approaches of preparation as well as motivation.
Yet Avery was the one that got all the high awards, such as at regionals, correct?
Yes, she did, but at the same time, I definitely think she erred on the side of luck as well as the side of her looks.
And you also admit to being you admit that you were sometimes jealous of these awards, correct? And that she would win them off of looks and not actual talent.
I was a little I wouldn't call it jealousy. I would say frustration that she didn't prepare as much as I did, and the fact that she went to the competition without preparation and made things up on the fly was a little frustrating for the entire team.
Mr. Cifuentes, I would like to move on to the incident between you and Ms. Becker and the text messaging. So you texted after the vandalism incident that you would help get Avery back on the team, correct?
Yes, that's correct.
And you believe that the team was better off without Avery, am I right?
Actually, one of the reasons why I got her back, I tried to get back her on the team, is because I recognized her talent, and that's one of the reasons why I decided to get her back on the team, because I knew that with state approaching, we needed her.
Mr. Cifuentes, it's not what I'm asking. I'm asking, you say in your witness statement that you believe that the team was better off without Avery.
In some ways, yes, because the amount of anxiety she put on the team, but at the same time, we definitely needed her for state that was approaching.
Okay. And didn't you also state that other witnesses were, teammates were angry that Avery was initially let back on the A team because it was not fair to the rest of the team?
Yes, that is correct.
And didn't you say that you were happy that Avery was gone so that you could take on her larger role?
I was excited to play a larger role, but I was not, in fact, excited to see her on the B team with, once again, all the losers. But at the same time, I definitely knew that she needed to be on the A team with all of her talents.
Thank you, Mr. Cifuentes. I would like to move on to the events with the cell phone and the location aspect. So you stated that you refused to give an investigator insight on the case, correct?
I didn't so much. Can you specify? I'm not really sure who you are talking about.
So in your witness statement, you stated that there was a private investigator on Avery's behalf that came to you and that you refused to give her any information, correct?
I refuse to give her information because, you know, I'm on the mock trial team. I'm not stupid. And the fact that this private investigator would come to my house to try to get information on me, to try to impeach me in court, was very frustrating and annoying, to be frank.
Okay. And you also stated that she could possibly impeach you as a witness by gathering information from your own will, correct?
Yes, that's correct.
Now, Mr. Cifuentes, I would like to move on to the events at the Fry Shack restaurant. So in your witness statement, you state that you were at this restaurant with the mock trial team, correct?
Yes, that's correct.
And Avery Becker was there as well, correct?
Yes, she was.
You also stated that you had a talk with other mock trialers about how Avery should forget about mock trial and move on.
The end of time.
Okay. Time is up on, I think, on the whole presentation, I believe.
No, Your Honor, that was the time for the cross.
Okay,
The 20 minutes for cross-examination had just exceeded right there.
okay.
And for direct, they only had 2 seconds left, so.
Counsel, do you wish to do any redirect in your 2 seconds?
No redirect, Your Honor.
Okay, thank you. Prosecution, do you have any further witnesses?
No, Your Honor.
Prosecution rest?
Yes, Your Honor, the prosecution rests.
Okay, thank you. Defense, call your first witness, please.
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand. Good evening, Professor Van Owen. Please state your name, spelling the last for the record.
Hello, my name is Blake Van Owen, Vanowen.
What do you do for a living?
My current occupation is as a private investigator, as well as a professor at Colorado University in the police practice and social justice departments.
Could you additionally fill us in on your educational background?
Yes, I graduated from Ashford University with a master's degree in criminal justice.
How did you initially get involved in your career?
I worked as a police officer in the Aurora Police Department.
And what are your topics that you're familiar with?
I'm familiar with police procedures, police practices, and social justice, as I am a professor at the Community College of the Rockies, as well as CU Denver.
What else have you done in your career?
I'm also known via my occupation as a school resource officer, as well as a private security guard.
In your particular areas of expertise?
I avail myself as an expert in police practice, use of force, and false arrest.
Anything else?
I also testify as an expert in crime scene reconstruction, forensic evidence, cell tower analysis, and general police investigation tactics, all of which I have been called to aid in court 22 times.
And have you been accepted as an expert in court?
Yes, in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, as well as the state courts in Colorado, Wyoming, Nebraska, and New Mexico.
How are you connected to this case?
I was put in charge of reviewing the police reports, the crime scene reconstruction, as well as Detective Markowitz's cell tower reports.
Your Honor, I move to have this witness, Professor Blake Van Owen, admitted as an expert in crime scene reconstruction and forensic evidence techniques.
Crimes, this witness is offered as an expert in crime scene reconstruction and, I'm sorry, cell phone evidence techniques. Did I hear that?
Techniques.
Cell phone evidence techniques.
Yes.
Okay. Any objection?
Yes, Your Honor. May I conduct a quick voir dire?
You may.
Professor Van Owen, you have not received any certification for crime scene reconstruction.
For crime scene reconstruction, well, I've testified as an expert multiple times in court, as I previously stated, as an expert in crime scene reconstruction.
Can you please answer the question?
Can you repeat the question, please?
Do you have any certification in crime scene reconstruction?
Certification, I believe that my teaching as a professor, as well as my expertise, is sufficient for me to be an expert.
And have you ever taken any training course in cell tower analysis?
No, I have not. But as I said before, I've been using it and I've testified as an expert multiple times in court.
Your Honor, I object to Mr. Van Owen's qualification as an expert because he lacks any education or training in the topics of cell tower analysis and crime scene reconstruction, so he's not qualified under Rule 702.
Response? You're on mute.
Sorry, Your Honor. So Professor Van Owen has been accepted as an expert in 7 different states. That being said, it is clear he has his experience with defense and is his expertise. Moreover, he has aided in crime scene reconstruction over 22 times and therefore has a pretty well experience with it.
Reply.
Prosecution stands by its previous objection.
The objection is overruled and this witness is deemed qualified as an expert in crime scene reconstruction and cell phone evidence techniques and may testify through opinion evidence pursuant to Rule 702 in those areas. Please proceed.
I would like to move on to your review of the crime scene, Professor Van Owen. While reviewing the case, did you find any contradictions associated with the crime scene?
Yes, well, Kuzik's entire case was built on the claim that there was some sort of brutal struggle between Brackman and Becker. There was only one undated scuff mark and nothing else to indicate any sort of fight.
Is there any evidence that
Objection, Your Honor, assumes facts not in evidence.
Response?
Your Honor, Professor Van Owen is an expert in forensic evidence. He has been doing this probably the longest in his career, and therefore he has experience with dating scuff marks. And it is a fact that you cannot date scuff marks, and therefore it is possible that these marks were there before the incident.
Your Honor, may I respond?
You may.
I admit that the expert witness has experience with scuff marks. However, the photograph of the scuff marks is not in evidence, so I would request that that the testimony regarding the contents of that photograph of the scuff marks be stricken from the record.
Well, the objection is overruled. This witness's answer to the question may stand. It is part of the basis of his opinion, and you can challenge the credibility of the basis for his opinion on cross-examination, but that's not grounds for his inability to testify as to the basis for his opinion. So the objection is overruled.
May I move on, Your Honor?
You may.
Thank you. Professor Van Owen, is there any evidence that might show how old those marks are, or any means that might say how old they are?
No, it is impossible to carbon date scuff marks. So the marks could have been there for years or months.
And the knife used in the killing did not belong to Brackman, correct?
That is correct.
Why is this significant?
Well, it is a different brand of knife than Brackman's home knives, and I wouldn't come to the conclusion that Brackman had purchased a different type of knife when all the rest in the block were the same.
In your professional opinion, the person would have to be taller than Brackman to stab him where the wound was, correct?
Yes, that is correct. Brackman was stabbed in the aorta, so a taller person must have stabbed him.
I would like to move on to the events of cell phone investigation, which will also include Becker's alibi. Did Becker have her phone on the day of the murder?
No, she did not.
Do you know where Avery Becker was that day?
Yes, she was at the mall that day, which was nowhere near the house.
And was anyone else with Becker that day?
Yes, Becker's best friend, Taylor Perkins, was also present.
Was this noted?
No, Detective Markowitz did not review Perkins' cell phone data.
To your knowledge, is there a reason as to why this wasn't documented?
In my professional opinion, it's possible that Detective Markowitz only looked at evidence that supported the claim that Becker did it, and he disregarded all other evidence that suggested that there was another possible suspect.
Objection, Your Honor, speculation.
Bonds?
Your Honor, during the crime scene investigation, it was indeed shown that there was significant evidence left out. Professor Van Owen did take the initiative to review this, and having known his expertise in reviewing, I would assume that his claims are valid.
May I respond, Your Honor?
You may.
The foundation has not been laid that Professor Van Owen is aware of the mental state of Detective Markowitz during the investigation, so he would not have any knowledge as to why Detective Markowitz chose to leave out specific pieces of evidence.
You have a response to that, counsel?
Your Honor, my response still stands.
All right. Objections overruled.
May I move on?
Okay.
How so?
Can you repeat the question? Can you repeat the question?
How so as to like why there wasn't a reason this was documented? Was the evidence or material inconsistent? Did it add up?
Yes, the evidence and the material was widely inconsistent.
Can you give an example?
Yes, so the tower records show that Perkins was and Becker were at the same location at the same time, which supports the notion of retracing to find Becker's phone.
Did Markowitz have access to these reports?
Yes, he did. He had clear access to this
Objection, Your
information.
Honor, leading the
but
witness.
Your Honor, I have not asked a yes or no question. I simply asked, did Markowitz have access to these reports, which I don't find any sort of notion that that's leading.
Well, the objection is overruled. It is a leading question, but this is additional background. So please proceed.
How could this evidence have helped the case?
Yes, this could have given us much more information.
What type of information?
This could have linked Perkins to Becker easier and could have exposed more data, giving us more information on the murder case.
Was it possible for Ms. Becker to be at the location the GPS implies?
No, she even has an alibi for that day.
Can you go into Ms. Becker's alibi, please?
Yes, Ms. Becker was with Taylor at the mall that day, which, as I said before, was nowhere near the house.
I would like to move on to the events of the cellular tower reviews by Professor Van Owen. So what did you find about Avery Becker's phone?
I found that Perkins had continuously texted and called Avery Becker's phone as if they were looking for it, retracing their way back through the mall.
Was this event ever recorded?
No, Detective Markowitz did not record this because it did not fit his original claim that Becker had committed the crime.
Your Honor, may I ask for permission for my timekeeper to screen share a copy of exhibits 15 through 16?
Please.
Is everybody able to see this screen share?
Yes.
I can see part of it. It's cut off at the top and bottom, I believe.
May I proceed, Your Honor?
Yeah, if necessary, please move the exhibit. That's better. Yeah, is that legible for everybody?
Yes.
Okay. Thank you. Please proceed.
Thank you, Your Honor. Do you recognize this, Professor Van Owen?
Yes, I do.
What is it?
They are the routes near Brackman's house where Miss Becker's cell phone was lost.
And
Cell phone was.
And did you take this picture?
No, Detective Markowitz did.
And is the route location accurate?
Likely not. The other cell towers nearby could have traced the phone and display the wrong location. Miss Becker and Mr. Perkins were also not at this location.
Your Honor, I move to have exhibits 15 through 16 entered as evidence.
Well, I was a little confused whether you were talking about 15 or 16 in your questioning.
Your Honor, I was talking about both.
Okay, let's take them one at a time. Exhibit 15 has been offered. Is there any objection to that exhibit?
Objection, Your Honor, hearsay.
Respond, please.
Your Honor, while Professor Van Owen reviewed these as stated in his witness statement, he did find that there were indeed multiple other cell towers nearby. So therefore, if it's in his witness statement, I don't believe that it is hearsay.
May I respond, Your Honor?
You may.
The witness has the ability to base his opinions off of inadmissible evidence, but the fact that this evidence is inadmissible under the hearsay rule still means that it cannot be admitted into evidence.
Response?
My answer still stands, Your Honor.
Well, under these circumstances, it's a question of probity, the probity value of the exhibit versus any prejudice. And I will admit this exhibit 15 because I think its probity value outweighs any prejudice that otherwise may exist or be caused by this exhibit. So the objection is overruled as to exhibit 15, and that exhibit may be admitted into evidence for all purposes. Now let's talk about 16, please. Would you offer 16 if you want to?
Yes, Your Honor. May I move to have exhibits 16 entered as evidence?
Any objection to 16?
Objection, Your Honor, hearsay.
Response?
Your Honor, both the, as stated before with 15 and 16 is linked with exhibit 15, so therefore they are hand in hand.
Any further response?
Yes, Your Honor. This exhibit, as I previously stated, states that, it is still hearsay regardless of whether the witness has testified about it in his witness statement or bases his opinion off of it, and it does not fall under any of the exceptions for hearsay.
Response on 16?
Yes, Your Honor. Your Honor, Mr. Van Owen reviewed this with detail and attention, and I feel, coming from an expert who has done this for a profession, I don't see how, or I don't feel that he did this out of prejudice, as stated before by the opposition, and it was included in his witness statement. So that concludes my response.
Your Honor, I would like to point out that this exhibit has already been admitted into evidence through Detective Jordan Markowitz.
You are correct. Thank you. Exhibit 16 already has been admitted. So please proceed.
Thank you, Your Honor. Mr. Van Owen, I would like to move on to the text messages between Becker and Cifuentes. So what about these text messages that were on his phone? What did you find out about them?
While it has not been proven whether this conversation was real or not, I grew suspicious of the screenshots of the messages that had been sent by Alex Cifuentes.
Why is that?
Well, there is no date, time, or cell phone number indicated on the screenshot. So in my professional opinion, that means these screenshots were fabricated.
Mr. Van Owen, I would like to move on to the events of other possible suspects you established for Brackman's murder. So is there anyone in particular who had a link or motive besides Avery?
Yes, a former client, Mr. Jonathan Rollins, was on trial for murder when Brackman lost the case. Mr. Rollins had screamed that he would get revenge on Brackman. Moreover, his son Blair had an obvious dislike for Brackman.
Your Honor, may I?
Objection, Your Honor, speculation.
Response?
Yes, Your Honor. So this recording is public record and has not been altered to the best of his knowledge. It is open to everyone, and therefore I believe that it can be used in court.
Your Honor, may I?
Yes.
The foundation has not been laid to show that Professor Van Owen has the personal knowledge to testify as to whether Blair Rollins liked or disliked Mackenzie Brackman, and any statement about Blair Rollins' feelings about Mackenzie Brackman is speculation.
Would you respond to that objection, please?
Yes, Your Honor. During the review, Professor Van Owen actually did find that Rollins did indeed have a hate for the mock trial coach. And this had also been a rumor spreading around the school. It was well known by all the students and staff that Rollins, after the case being lost by Brackman, developed a resentment and hate towards the mock trial coach.
Your Honor, may I respond?
You don't need to. I'm going to sustain the objection. I haven't heard that the question that you asked is answerable by this witness because of any observation, personal observation that he may have had of Blair Rollins or the victim or anybody else. If you have any such if you can develop any such foundation for your question, you may proceed to do so. But for now, under what's before the court at this time, the objection is sustained.
Yes, Your Honor. May I lay foundation?
You may.
Okay. Professor Van Owen, what does this recording entail?
This is the recording of Mr. Rowland screaming that he would get revenge on Brackman because he lost his case.
And how did you get this recording?
I got it through the courts. It was public information.
And in your professional opinion, do you believe that this displays a high level of resentment as compared to that of Becker's?
Yes, using my expertise and knowledge as a expert, I do believe that there is clear motive.
And to your knowledge, has this recording been tampered with?
Not to my knowledge, because it is from the courts.
And how did you find out that, how did you discover that Blair Rowlands had a dislike for Brackman? By viewing the video, through his tone in the screaming that he would get revenge, it was clear to me, and it was also knowledge at the school that Brackman had a dislike, or that Rowlands had a dislike for Brackman because he lost the case. And were there any additional findings, Professor Van Owen?
Yes, there were. I conducted an extensive search for Mr. Rowlands, and I could not find him. I suspect that he left the state of Colorado.
Your Honor, may I resort to having laid sufficient found evidence and again request that Exhibit 22 be considered for being entered as evidence?
Okay, did you formally offer Exhibit 22 previously?
No, I don't believe so, no.
Are you doing that now?
Yes.
Okay, Exhibit 22 has been offered. Is there any objection?
Your Honor, I would request that opposing counsel play the audio for the jury prior to admitting it.
Yes, Your Honor.
Play the audio for the witness.
That's fair. Go ahead and play it.
Okay, I'll have my screen share and we'll go to the exhibit.
A quick question, was everybody in the court able to hear that?
No.
I didn't hear it.
Okay. Let me try this again.
I'll get your back, Blackman, if it's the last thing I do.
Yes, that was audible.
Has the exhibit been heard? Okay.
All right. Please continue either with your examination or if you have an objection, please.
Yes, Your Honor. I object on grounds of hearsay, and under Rule 703, this evidence, the prejudicial effect of the evidence outweighs its probative value.
Response?
Your Honor, this was taken, Your Honor, this was and by no means, I don't see this being like prejudiced towards Blair or any other witness besides Becker. It is merely a matter of public record, and that even though this was not actually Blair Rowland speaking, it was the father, Jonathan, speaking. So therefore, I believe it is relevant to this case, and will play a big role in finding out who the suspect is.
Response?
Your Honor, this case is against Avery Becker, and while it is relevant to show any other suspects, the prejudicial effect that this recording will have on the jury far outweighs its probative value in relation to Blair Rowlands.
Objection is overruled. Exhibit 22 is admitted into evidence for all purposes.
Thank you, Your Honor. And my final question, was Blair located on the day of the murder?
No, Blair was absent from school that day, and his location was unknown and still is unknown.
Thank you, Professor Van Owen. That will be all, Your Honor.
Cross-examination?
Yes, Your Honor. Professor Van Owen, you testified about Exhibit 22 in your direct, correct?
Yes, I did.
You agree, don't you, that Jonathan Rollins says, quote, "I'll get you back, Brackman, if it's the last thing that I do"?
In the audio recording from the Rollins case, yes, Mr. Rollins does scream that he's going to get revenge on Mackenzie Brackman. That is correct.
And in your witness statement, you stated in lines 255 to 256 that, quote, "Jonathan Rollins said that Brackman was going to die," end quote. Is this correct?
Yes, yes, I said that in my witness statement. That is correct.
So you admit that this is an inaccuracy in your witness statement?
I beg your pardon?
So you admit that this is an inaccuracy in your witness statement?
I am a little confused on what you're saying is inaccurate.
In your witness statement, you said that Rollins said that Brackman was going to die, but then you just said that the recording actually says that Rollins said that he would get revenge on Brackman.
Could you pull up the witness statement for me?
Yes, may the let the record show that I'm asking my timekeeper to pull up Blake Van Owen's witness statement.
This will be Exhibit 22. Oh, I'm sorry. You asked about the witness statement.
Yes, a
not
copy
the
of.
recording. Okay, sorry.
Yes, Your Honor.
Okay, sorry.
Lines 255 and 256.
Okay, great. I was just going to ask that. I stopped the time for the record.
Now, am I correct in saying that from lines 255 to 256, you say Jonathan Rollins yelled out that Brackman was going to die?
Yes, that is correct.
And just now you testified that Exhibit 22 actually states, quote, "I'll get you back, Brackman, if it's the last thing I do," end quote, not that Brackman was going to die.
Objection, speculation.
Response?
Your Honor, I am impeaching the witness because in his witness statement, he stated that Jonathan Rollins said one thing, and he just testified that Jonathan Rollins said another thing in the recording that we all just heard.
Reply.
Your Honor, Professor Van Owen reviewed this and saw that, yes, he indeed did say that that Rollins did indeed say, "I'll get you, Brackman, if it's the last thing I do." However, this was out of revenge in the sense that Rollins wanted to get back at Brackman for losing his case. Therefore, I don't think it's a matter of reciting the witness statement verbatim. It's trying to prove a point.
Well, I will overrule the objection. I don't see any speculation here. That was your objection as I heard it. So that objection is overruled, and counsel, you may proceed in your questioning along this line.
Thank you, Your Honor. Professor Van Owens, to repeat, you do admit that your witness statement was incorrect in saying that Jonathan Rollins yelled out that Brackman was going to die.
I think there's a very fine line in assuming that that getting back at someone is saying that he's going to I don't know, in my professional opinion, that I think that says it's going to be a murder or something. So I think there's a very fine line between it, but I in my professional expertise, this is a minuscule detail.
But that is an inaccuracy in your witness statement. That is not exactly what Jonathan Rollins yelled out.
It was my interpretation of it.
It's actually
And as an expert, I think I'm allowed to make those assumptions and connections.
Professor Van Owen, I would ask that you proceed to answer questions in a yes or no fashion. I will
Could you
move
repeat
on
the
to my
question
next
then?
line of questioning.
Okay. All right.
You did not visit the crime scene, correct?
No, I did not visit the crime scene in the murder of Mackenzie Brackman. That is correct.
And that makes it more difficult to come to the correct conclusion, correct?
I'm a private investigator. I think my experience and expertise allows me to come to conclusions. I did not feel that it was necessary.
Regardless, all of the physical evidence that you relied on was photographic and videographic evidence that was obtained by the police.
Yes, the police did obtain the photographs, and if the police, yes, that is correct.
Now, let the record show that I am asking that my timekeeper show a video of Exhibit 12. Now, Professor Van Owen, you agree that the door made noise in that video, correct?
I could not hear anything.
Your Honor, may I request to show that video again so that the witness may hear the audio that accompanies it?
Certainly.
I still did not hear.
Sorry, that was
anything.
because I was muted. That was totally a mute.
Oh, okay.
To repeat, Professor Van Owen, you do agree that the door makes noise?
Yes, the door in the video did make a noise.
And it is your theory of the case that the victim stayed seated at the kitchen table until the intruder stabbed him, correct?
Yes.
So then you believe that the victim stayed seated while the intruder loudly opened and closed the door, walked across the room, and then stabbed the victim, correct?
Yes, that is correct. But in the video, you can hear that there were outside noises like that car that went past. So the victim may not have heard it.
Your Honor, I would request that you instruct the witness to respond to my questions in a yes or no fashion.
Yes, Mr. Van Owen, please answer as briefly as possible. This is cross-examination. And if you wish, or if your attorney wishes, or I'm sorry, counsel for the opposing party wishes you to elaborate on any of your questions, you'll have that opportunity through
Yes, Your Honor.
opposing counsel. But please answer yes or no, or as briefly as possible if you can't answer yes or no.
Yes, Your Honor.
Okay, please proceed.
Thank you, Your Honor. Now let's talk about your investigation. It's true that you called the police investigation rushed.
Yes, I believe that the police investigation was rushed.
And you also think that they came to the easy conclusion.
That is correct.
But it's true, isn't it, that you also came to a predetermined conclusion?
I used the evidence that I found to come to a conclusion, while Detective Markowitz had the notion that Avery Becker committed the crime well before the evidence was found, and then he disregarded all other evidence that suggested otherwise.
Your Honor, I would request let the record show that I'm requesting that my timekeeper display a copy of Exhibit 20. Professor Van Owen, do you recognize this document?
I cannot read any of it. It's incredibly small. Yes, yes, this is my witness statement. I do recognize this.
And this is a copy of your report.
That is correct.
And when did you create this report in the usual scope of your business?
Yes.
Your Honor, I move to admit Exhibit 20 into evidence.
Response?
No objections, Your Honor.
Exhibit 20 will be admitted for all purposes. Let me ask first, stop the timing. Was Exhibit 12 ever offered or intended to be offered?
It was offered through Detective Markowitz.
I thought it had been withdrawn. Let me check. Yeah, my notes indicate it was withdrawn before a ruling was made on its admission.
Yes, that is correct.
Okay, do you want it admitted now?
No, Your Honor.
Okay. Sorry for the interruption. Please proceed.
Professor Van Owen, I'm going to read the first sentence that begins your second paragraph. In it, you state, "I have been asked to offer the following opinions on behalf of the defense in this case." Is that correct?
Yes, you just read it. Yes, that is correct.
And these opinions include the fact that Mackenzie Bracken was surprised, the fact that Becker's phone was not at the crime scene, and the fact that the prosecution's case was not methodologically sound. Is that correct?
That is correct.
So the defense asked you personally to give these opinions in court today?
Yes.
And they asked you to come to these conclusions during your investigation?
I came to these conclusions on without a forced hand. So, but to your, can you rephrase your question? I'm a little confused.
Of course, you knew that you were working for the defense and that they wished for you to come to these conclusions while you were conducting your investigation.
I was only offered to give these opinions for the defense.
But you were working for the defense while you were conducting your investigation?
Yes, that is correct, because Detective Markowitz did an insufficient job.
Once again, I would request that you answer only with a yes or a no. Thank you.
Yes.
And you also think that, thank you, timekeeper. This is not necessary anymore. You also think that Detective Markowitz should have looked into more phone records than just those of Avery Becker?
Yes, that is correct. A good detective would look into more cell phone records.
But it's true, isn't it, that you didn't look into these phone records at all?
I didn't have access to these phones while Detective Markowitz at the time did.
Isn't also true the only successfully interviewed two people, Taylor Perkins and Avery Becker?
Yes, that is correct.
Thank you. Now we'll talk about the text messages from Alex Fuentes. You think that Alex Fuentes faked these text messages, correct?
I believe these text messages were fabricated.
So then you're trusting a kid, the defendant, more than you're trusting the police investigation.
In my expertise, looking at a screenshot of a message with no time, no date, or phone number attached, I came to the conclusion that these appear fabricated.
Thank you. Now, you frequently avail yourself as a witness in police practices, use of force, and false arrest.
Yes, that is correct.
And you have only ever been a witness for the defense.
Yes.
So you always testify against the police.
Yes.
And now, in this case, you believe that Detective Markowitz, a police officer, planted the idea that Becker was the intruder into crime scene reconstructor Kyle Cusack's mind, who is a civilian employee.
Was there a question there?
Yes, you do believe that Markowitz planted the idea in Cusack's mind, correct?
I do, correct.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor.
Please proceed.
Thank you. Okay. So Professor Blake Van Owen, so as the prosecution stated, you have only ever been a witness for defense, correct?
That is correct.
And do they believe that because of this, you witness against the police, that you're against the police in court?
From their questioning, it appeared that way.
But you were once a police officer, correct?
Objection, Your
That
Honor.
is correct.
I'm sorry, what was the objection?
Leading the witness.
Your Honor, may I rephrase the question?
You may.
Do you have any experience with policing?
Objection, Your Honor.
Yes, I worked in the Aurora Police Department.
Hold it. There's an objection pending, and I didn't hear it because at least one other person, maybe two, were still talking. Please restate your objection.
Objection, leading the witness.
Response.
Your Honor, I tried to reword my statement as best I could. If I need to do it again, I will.
Please do so.
Okay. Okay. So while they believe that you are against the police, do you have any connections in police practices?
Yes, I worked at the Aurora Police Department.
So therefore, you would have knowledge in any police tactics and forensic evidence, correct?
Objection, Your Honor, leading the witness.
Response?
Your Honor, may I reword my question?
You may.
Okay. So therefore, if you were at the Aurora Police Department for a while, would you say that you were there long enough to have experience in the forensic area and in the tactics?
Yes, I believe, I believe that, and I'm also a professor in these fields.
And how long have you been teaching for as a professor in police practices?
It's a little hard to say.
Would you say that you've been there for a long amount of time?
Yes, a long amount of time, but I don't recall the exact amount.
And you have been called to aid in court on forensic evidence and on policing tactics about 22 times in court, correct?
Objection, Your Honor.
That is
leading
correct.
Your Honor, may I rephrase my question?
You may.
Okay. So whereas you have been a police officer for a long time and have aided in court about 22 times, would you say that you have the credentials that are good enough to make this assumption?
Yes, I believe I do.
No further questions, Your Honor.
Okay, thank you.
Thank you. Defense, please call your next witness.
Your Honor, the defense calls Taylor Perkins to the stand.
Please proceed.
Good afternoon, Mr. Perkins. Please state your name, spelling the last for the record.
I am Taylor Perkins, Perkins.
Do you know the defendant, Avery Becker?
I do. She's my best friend, and we're in mock trial together.
Did you know the victim, Mackenzie Brackman?
Yes, I do. He was my mock trial team coach before I quit the team.
What was your relationship like with Mr. Brackman?
Avery and I always thought he was a mediocre coach and lawyer. He also made insensitive decisions for the team, like demoting.
Objection, Your Honor. Speculation.
Response?
My witness is testifying as to what he knew from being on the team. He witnessed everything he's talking about.
Well, would you rephrase the question so that it asks him about his personal observations?
Your Honor, the question was asking him about his
Why don't you re-ask the question, please? Re-ask the question,
Okay.
please.
What was your What was your relationship like with Mr. Brackman?
I thought he was a mediocre coach and lawyer. I also saw him make insensitive decisions for the team, like demoting Avery to the B team.
How did Ms. Becker react to getting demoted to the B team?
Avery was really upset.
Objection, Your Honor. Lack of personal knowledge.
Response,
I can rephrase the question.
please.
What did you observe about Ms. Becker after she was demoted to the B team?
She was upset. Mock trial was very important to her, and in response, I quit the team. Brackman was forced to put Avery back on the A team.
Did Mrs. Becker ever get kicked off the mock trial team?
Yes, she did.
Objection, Your Honor. Leading question.
Response,
I'll move on.
okay, please do so.
What did you observe about Ms. Becker after she was kicked off the team?
Again, she was really upset and she had everything to get back on the team. We went to the Fry Shack to think of ideas to apologize to Brackman.
What happened at the Fry Shack?
Well, the mock trial team came in and said how unfair it was that Brackman kicked her off. And then Alex
Objection, Your Honor. Hearsay.
Response,
Can you explain the hearsay objection?
You mentioned what the mock trial teammates said regarding it, which is an out-of-court statement.
response,
I will move on.
okay.
Do you know Alex DeFuentes?
I do. Alex was always jealous of Avery, and he was a total kiss up to Brackman. Avery always got the best awards, like best attorney, even when she didn't prepare. Once Avery was out of mock trial, Alex finally had his chance to shine. Alex was also good friends with Blair Rollins.
What can you tell me about Blair Rollins?
Well, I don't know that much, but I do know Brackman defended his dad and lost. I also know Blair's kind of weird. He's the kind of kid you'd vote most likely to be a, sociopath or a hitman.
Okay, I would like to move on to the events of March 6, 2020. Would you please tell the jury what you did on that day?
Well, I texted Avery asking if she's going to pick me up for school like she does every other day. Sometimes I drive, but sometimes I go with Avery. And she didn't reply. When she finally pulled up, I asked her why she didn't answer my text, and we realized her phone was missing.
What did you do after realizing that her phone was missing?
We ditched school and we went looking for it. We first went to the mall and some stores we've been into the other day to see if she left her phone in there. And then I remembered she left her phone at the Fry Shack table when she got frustrated the night before.
What else happened that day?
Well, I texted and called the phone to no avail. At the Fry Shack, the mock trial team came in and said Brackman never showed up to practice, so they left.
Objection, Your Honor. Hearsay.
Response?
I can move on.
I'm sorry? I
I'll
didn't
move
hear.
on. I have.
Okay, all right, thank you.
To be clear, Mr. Perkins, you spent the entire day with Ms. Becker, and the two of you were nowhere near the victim's house.
Yes.
Objection, Your Honor. Leading question.
Response?
I have no more questions, Your Honor.
Do you want to rephrase that last question?
Sure. Mr. Becker, can you please summarize what you did on March 6th?
We were nowhere near Brackman's house looking for Avery's lost phone.
Okay. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor.
Please
Good
proceed.
evening, Mr. Perkins. You have known Avery for a long time.
Yes.
You are best friends with Avery.
Yes.
You even joined mock trial because of Avery.
Yes.
And you also help her whenever she needs it.
Yes.
You didn't like Brackman's coaching style?
He was mediocre.
Sorry, I didn't hear that. Could you say that again?
I said objection, relevance.
Response?
Your Honor, if you would give me some latitude, I will continue to explain going down this line of questioning. Along with Brackman's coaching style. Sorry, let me rephrase that. Taylor and Avery.
Wait. Where are you going with this line of questioning?
Yeah, let me rephrase that. Through this line of questioning, I seek to show Avery's disagreements and discontent with Brackman fueling motive for this crime.
Any response to that?
No response, Your Honor.
All right, please proceed. Objections overruled.
You didn't like Brackman's coaching style?
He was mediocre.
Neither did Avery.
Yes. Yes.
In fact, Avery and Coach Brackman did not get along at all.
They had a little feud. It wasn't much.
Their disagreements became fights.
Not fights, just a little feud. They didn't brawl.
Would you call vandalizing a car a little feud?
It was a prank.
So you would call vandalizing a car a prank?
She didn't mean it as vandalization. She just wanted to scare him a little bit.
All right. Well, let's move on. Let's talk about the fight Avery had when she was demoted from A to B team. Avery needed your help to get back on A team.
Yes, she did.
You decided to step down from the mock trial team a week before the regional competition.
Yes, but mock trial wasn't as important to me as it was to her. I didn't want to be a lawyer.
You did this to get Avery back on the team because you knew that Brackman would have to bring Avery back to the A team.
Yes, but it
So
wasn't
you
important to me. It was important to her.
So you sacrificed your position for Avery.
I only joined mock trial to be with my best friend. It wasn't important to me.
Yet you still, despite putting time and effort into mock trial, you were willing to give that all up for Avery, correct?
Yes.
And after regionals, Avery really snapped.
Yes.
Avery grabbed a marker and wrote on Brackman's car.
She thought it was dry erase.
Avery didn't tell you she regretted it.
No, she didn't.
Avery told you the mistake she made.
No, she said it was dry erase. She texted me the night of.
So she said her mistake was that she used a permanent marker.
No, she told me the night of writing on his car that it was an expo marker, not permanent marker.
Yet this was her mistake.
It was her mistake.
Avery was desperate to do anything to get back on the team. Is that correct?
Yes.
She even went to Brackman in person to apologize.
Yes.
She texted everyone on the team for help.
Yes.
Nothing worked, did it?
No, it didn't.
Let's move to the evening of March 5th, the day before the murder. You had an encounter with the mock trial team at the Fry Shack.
Yes.
And while at the Fry Shack, you claim that Avery stormed off and left her phone on the table.
I think she left her phone at the table and she was talking to Alex Fuentes before she stormed off.
Now, let's move on to the day of the murder, March 6th.
Mm-hmm.
You realized Avery's phone was missing that morning.
Yes, we realized her phone was missing.
Yes. And you and Avery skipped school to look for the phone.
Yes.
But you only looked in two places, the mall and the Fry Shack.
Yes.
Avery's phone was like her third kidney.
Yes, but people can still lose things.
It was very important to her.
Again, yes, but people can still lose things.
You admit that you could have found the phone using the iCloud website.
I didn't think of that, to be honest.
Please answer the question.
Yes, I didn't think of using the iCloud website.
And while at the Fry Shack, in looking for the phone, the mock trial team said Brackman never showed up to practice.
Yes.
You later found out that Brackman was dead.
Yes.
And you claim that when Brackman was murdered, you and Avery were together.
Yes.
No one else knew about Avery's whereabouts that day but you.
Yes.
After Avery was charged with the murder, her lawyers contacted you to be a witness.
Yes.
And it was Avery, wasn't it, who suggested that there was an alternate suspect after she was being charged?
Yes, she said Blair Rowlands, but it makes sense.
You say some very strong things about Blair, and why it would make sense he would be guilty.
Yes.
Yet you still, despite believing all of this, would never have guessed it was him.
Yes.
You never heard about any conversation Avery had with Alex.
Well, I did see the encounter at the Fry Shack, and that told me all I needed.
You didn't mention suspecting Alex to be any part of this.
Yeah, the rumor about the screenshots seemed kind of random.
Avery, out of the blue, says that Alex has fake text messages of him.
Yes.
You didn't mention even talking with Avery about Alex prior to this.
Yes.
But you do not actually know whether Alex ever had Avery's phone, do you?
I don't. I don't know.
That'll be it. Thank you, Your Honor. No further questions.
Any redirect?
No, Your Honor.
All right. Thank you. Defense, please call your next witness.
All righty, the defense calls Miss Avery Becker to the stand.
Please proceed.
All right, good evening, Miss Becker. Could you please state your name and spell the last for the record?
Avery Becker, B-E-C-K-E-R.
And Miss Becker, could you please tell the jury a little bit about yourself?
Yes, I was a senior last year at Colorado High School, and I participated and excelled in mock trial for all 4 years at CHS.
And how involved were you in mock trial?
It's almost like a part of me. I started freshman year and immediately felt as if I was in my natural habitat. It's also a very important part of my social life. My best friend Taylor Perkins does it with me, and we hang out all the time outside of practice.
And how well did you do in mock trial?
Extremely well. I won Best Attorney Award, and I was pretty confident I was going to win Best in State.
Now you say that you were confident about it. What happened?
Well, mock trial came naturally to me, like I said, so it was a lot more natural for me to stay present with the case and work on the fly over the scripts that our coaches made for us.
And what was the reaction of the coaches when you did not use the script?
Not using the scripts didn't settle well with the main coach, Mr. Brackman, but my chances for winning this award became nigh when I was forced off the team.
And what was your relationship like with Mr. Brockman?
I respected him as a coach because he brought up the competitive side in our team, but he would always attack me and my work ethic because it was different than his. He also never dished out credit where credit was due.
And what kind of tension did this cause?
It caused a lot of tension between him and I. He constantly criticized everything I did, and most of the time it was totally undeserving.
And what did this tension arise to?
About a month before regionals, he moved me to the B team despite my awards and aptitude under the excuse of poor work ethic.
And then what happened?
I did eventually get back on the A team because Taylor felt bad for me and sacrificed his spot, so Brackman had to bump me back up.
And what happened after the mock trial tournament?
I won Best Attorney Award and was named the best closer, and per usual, Mr. Brackman degraded my achievements by saying I didn't deserve it and blamed it all on luck.
And how did you respond?
I regret my response more than anything. After our fight, I stormed out of practice with the marker we were using to outline our tournament achievements.
And then what happened?
I took the marker, which I thought was dry erase, and wrote Worst Attorney Award across Mr. Brackman's Porsche.
And what was Mr. Brackman's response?
Mr. Brackman saw me with the marker and completely flipped out. He then kicked me off the team for seemingly forever, and it destroyed me. After an emotional conversation with my mom, she suggested I make amends with him in order to rejoin the team.
And how did you attempt to make amends?
I tried to apologize in person, but Mr. Brackman refused to see me, so I sent him a text expressing how sorry I was. Then I offered to scrub the car to get the marker off and pay for it to get repainted.
And how did Mr. Brackman respond to this?
He completely ignored me. I never even got a chance to apologize in person before he died.
And Ms. Becker, do you know where Mr. Brackman's place of residency was?
No.
I'm really sorry for your loss. I can't imagine what it was like losing a leader like that in your life. Is it all right if we move on to the leading events in the day of the murder?
Yes.
So the day before the murder happened, could you go over your activities?
I went to the Fry Shack and saw some other mock trialers there.
And who was there at the Fry Shack?
The majority of the team, including Alex Cifuentes.
And why is this significant?
Alex and I never got along. She was always jealous of my accomplishments in mock trial.
And what happened after you left the Fry Shack?
I'm sorry, what was the objection?
Your Honor, objection speculation.
Response?
So, Your Honor, the witness is simply testifying to her relationship with Mr. Cifuentes, and that is within her scope and what she can testify to as is talking about her relationship.
Response?
Your Honor, the witness stated that Mr. Cifuentes was jealous of her. She cannot testify to Mr. Cifuentes' state of mind.
May I respond, Your Honor?
You may.
My witness can also infer based on his activities and also the interactions that they have on his emotions and his reaction to her achievements.
Objections overruled.
Thank you, Your Honor. I'll continue. So, Ms. Becker, I'm going to repeat my question. So why is it significant that Mr. Cifuentes was at the Fry Shack with you?
Like I said, Alex and I have never gotten along. He was always jealous of my accomplishments in mock trial.
And what happened after you left the Fry Shack?
Taylor and I just walked around the mall like we do all the time, and then the next morning I couldn't find my phone.
And what happened next?
The next morning I went to Taylor's house, and we decided to spend the entire day together retracing my steps looking for my phone. Went to the mall and the Fry Shack and looked everywhere, and we constantly called it from Taylor's phone and got no answer.
Now, Ms. Becker, is it possible to be in two places at once?
Not that I know of.
So could you have committed second-degree burglary, criminal mischief, and first-degree felony murder, which I'm sure you're aware of the charges that brought you here today. At the same time, you were at the mall with Ms. Perkins looking for your phone?
No.
Action, Your Honor, leading the witness.
Response?
Your Honor is not leading the witness, as it is a open-ended question, which allows for other like confirmation, other evidence narrative to come into play.
I'll sustain the objection, but you may rephrase the question if you wish to pursue that line.
Now, Inspector, are you aware of the charges that brought you here today?
Yes, I am.
And Ms. Becker, you previously stated, and Ms. Becker, could you go over your alibi on the day of the murder?
I was with my best friend Taylor looking for my phone all day.
So would it have been possible for you to have committed these crimes while you were at the mall?
No.
All right, thank you. And Ms. Becker, I'm going back to talking about your phone. So what do you think, to the best of your knowledge, happened to your cell phone?
The last time I remember having my phone was at the Fry Shack with the team, and the last person I lent it to in order to play games was Alex.
Now, you already stated that you and Mr. Solfuentes didn't have a positive relationship. Can you think of a reason why?
Alex always wanted to be the big mock trial star, even though I was the one who got the awards.
And Ms. Becker, why are you on the stand here today?
I'm on the stand because I was an easy target. My relationship with Brackman was rocky, sure, but he was still an important adult in my life. He was the coach who brought us to state.
And once again, I'm going to turn your attention to a different aspect of this case. I'll be addressing one of your classmates, Mr. Rollins. Do you know Blair Rollins?
Yes, I do.
And what was your relationship like with him?
Him and I weren't close, but everybody knew that Blair hated Brackman after he lost the case that sent his dad to jail.
And to the best of your knowledge, based on that case, what was Mr. Brackman's relationship like with his clients?
Very poor. It was common and public knowledge he wasn't good in court and wasn't good with clients, which was reflected in Rollins' case.
Ms. Becker, I'm once again so sorry for your loss and sorry that you're being dragged through the mud on this. That's all my time for now. Thank you.
Thank you.
Cross-examination?
Yes, Your Honor. Good evening, Ms. Becker.
Good evening.
You were on mock trial for almost all of your high school career.
Yes, it was really important to me in high school.
And mock trial meant a lot to you.
Yes, like I just said.
And you were one of the highest performing students on the team.
Yeah, I won best closer and was awarded best attorney at regionals last year.
Ms. Becker, I'd like to remind you that a yes or no answer will be sufficient for most of these questions.
Oh, sorry, I didn't know that.
Coach Brackman did not appreciate your talents, did he?
No, he blamed a lot of my accomplishments on luck.
And he was always revising your examinations.
I like to work on the fly over the scripts that he provided for us, and that just didn't really settle with him.
And so he was always revising your examinations.
Objection asked and answered.
Response?
Your Honor, the defendant, the defendant did not actually answer my previous question.
I respond, Your Honor.
Objection overruled.
Thank you, Your Honor.
You never needed all of that help from Brackman, did you?
Objection relevancy.
Your Honor, this is relevant. Yes, Your Honor, this is relevant because I'm establishing the rocky relationship the defendant had with Coach Brackman, which will establish motive.
Reply.
Your Honor, based on how much help the Ms. Becker needed from her coach isn't really relevant to this case, not really relevant to their relationship as well, as it only pertains to one aspect, and because Mr. Brackman also cannot testify to what his team member needed from the team.
Objection is overruled. Please proceed.
Thank you, Your Honor.
Ms. Becker, you never needed all of that help from Brackman, did you?
I definitely did have natural talent, but Mr. Brackman guided our team and brought out the competitive side.
Now, Mr. Brackman demoted you in your senior year to the B team, correct?
Yes, he did.
And in your words, the B team is a bunch of losers.
Well, I just knew my talents wouldn't be fully appreciated on the B team. I knew I could do better.
Ms. Becker, that didn't answer my question. In your words, the B team is full of losers.
Well, they weren't full of winners.
And so that must have been humiliating for you.
I feel like it would be to everybody.
But Mr. Brackman had to bring you back to the A team before regionals, didn't he?
Yes, he did.
Because your best friend, Taylor Perkins, quit the A team for you.
She did it because she's a good friend and it didn't really mean that much to her and she knew how much it meant to me.
All right, thank you. And now, even after the regional tournament, where you won plenty of awards, Mr. Brackman did not appreciate your contributions to the team.
No, he didn't. He said I had poor work ethic despite my awards.
This must have made you incredibly angry.
I feel like it would make anybody angry.
Ms. Becker, you acknowledged in your witness statement that you knew Mackenzie Brackman owned a Porsche.
Yes, I did. Most of us did.
Relevancy.
Your Honor,
Response?
Your Honor, this evidence is relevant because, again, I'm establishing the volatile nature of the witness's relationship with Coach Brackman, and the seriousness of vandalizing his Porsche is pertinent to that relationship.
May I respond, Your Honor?
You may.
What car Mr. Brockman drove isn't relevant to this case, nor is it relevant to any activities that may have happened.
Objections overruled.
Thank you, Your Honor.
Could you repeat the question, please?
Yes, Ms. Becker, you knew that Mackenzie Brackman owned a Porsche.
Most of us did. He made it pretty obvious.
And you knew that he loved this Porsche.
Yes,
Objection.
he did.
Calls for speculation. Because Ms. Becker cannot testify to Mr. Brockman's relationship towards his car, and therefore this question calls for speculation.
Response?
In the witness's written statement, she testified that she knew Coach Brackman loved his Porsche. I'm only referring back to her words.
May I respond, Your Honor?
You may.
Those are not the direct words that she used. And therefore, Mr. Brockman's relationship with his car isn't already established within Ms. Becker's witness statement, and therefore she cannot testify to it.
Response?
Your Honor, the witness just testified that everybody on the team knew that Coach Brackman loved his Porsche because he made it clear. Therefore, it is within the witness's rationally based perception that he loved his Porsche.
The objection was relevant, and that objection is overruled.
Thank you, Your Honor.
Your Honor, you knew that Mackenzie Brackman loved this Porsche, and yet you still...
Objection, compound question.
Your Honor,
Yeah. Counsel, allow the question to be asked before you object to it, please.
Apologies.
Please re-ask your question.
You knew that Mackenzie Brackman loved his Porsche.
Yes.
And knowing the value of this car, you still decided to vandalize it with a permanent black marker.
I thought the marker was dry erase.
But you still vandalized it.
I've never said that I didn't.
Thank you. Let's move on to directly after this incident of you vandalizing his Porsche. Mr. Brackman then dismissed you from the mock trial team, correct?
He did, and it was heartbreaking.
Yes, your senior year, correct?
Mm-hmm.
Right before the state tournament.
That's correct.
This must have been devastating for you.
It was.
Now, I'd like to move on quickly to the events on March 5th. You think that it was Alex Cifuentes, who you say you're not friends with, who took your phone, correct?
To the best of my knowledge.
Compound question.
Response?
I do not believe I asked multiple questions within that.
May I respond, Your Honor?
You may.
So the attorney is asking relationship with Alex Cifuentes and reaction to the phone, and therefore it's a compound question, therefore it's a compound question.
All right. Please rephrase.
You say you're not friends with Alex Fuentes.
No, we've never really been close.
And yet you say he is the one who took your phone.
To the best of my knowledge, I think so.
Now, Ms. Becker, Alex Cifuentes is not the one who was kicked off the mock trial team his senior year, correct?
Well, Alex was a junior last year, so.
He was not the one who was kicked off the mock trial team, which was incredibly important. Yes?
That's correct.
Thank you, Your Honor. I have no further questions.
Okay, good. I was about to say time's up, so.
Maybe 1 second left.
Maybe a couple milliseconds there.
Timekeeper, do we have time for any redirect?
Yes, Your Honor, there is about 4 minutes of time left for the direct.
Okay. Do you wish to engage in any redirect?
Yes, Your Honor, just a brief one, if that would be all right.
Okay, please do so.
Ms. Becker, so it was previously stated in your cross statement view, there was a vandalization incident with Mr. Brockman's car. I'm going to address that. So after the vandalism incident, can you explain what happened?
Mr. Brackman kicked me off the team and I was devastated. I went home to my mom and I was heartbroken. And she suggested that I'd text him or try to apologize in person. I mean, obviously I tried and I couldn't, but I really tried to apologize and Mr. Brackman just didn't allow me to.
Ms. Becker, how do you think the way that you make amends ties into your mindset after the vandalization incident?
I felt so bad and I would do anything to get back on the team.
And Ms. Becker, would you also agree that the way that you make amends could also portray a remorseful tone?
Of course. I feel so horrible about it still to this day.
Ms. Becker, once again, I am so sorry for your loss. Thank you for your time. That is all, Your Honor.
All right, thank you. Defense, do you have any further witnesses?
The defense rests, Your Honor.
Counsel, are you ready to proceed to closing arguments?
Yes, Your Honor.
Yes, Your Honor.
Please do so.
Ladies and gentlemen of the jury, here today is an example of revenge. We see Avery Becker pushed to the edge. We have met the burden of proof, and we have shown you that Avery Becker is guilty of this heinous act of second-degree burglary and first-degree felony murder beyond a reasonable doubt. As you have heard from multiple witnesses today, Avery Becker is a rash, hot-headed person. They rarely give a second thought to their actions, as we've heard from both Alex Cifuentes and Taylor Perkins, Avery's friends. On top of this, these dramatic and over-the-top pranks, if you could even call them that, are a habit for Avery. They admitted this. Not only has she committed numerous so-called pranks on Mackenzie Brackman, she even went as far as vandalizing Brackman's car. We wouldn't even be here if it weren't for Brackman's gracious acts of not pressing charges. Now, instead of pressing charges, Brackman took the merciful route and simply kicked Avery off the team, a somewhat meaningless consequence in relation. But that was not enough for Avery Becker. She felt she was unjustly treated and decided to retaliate. Avery then texted Alex, threatening to trash Brackman's house, as you heard the experts talk about. It would only seem to be someone of Avery's caliber and behavior, as we see with the car, to do such drastic measures over simply being kicked off the mock trial team. And along with them, their accomplice Taylor lied to keep their best friend, who they would do anything for, safe from the eyes of justice. Taylor would go to such measures for Avery, including how he willingly dropped mock trial for Avery's sake. And let's think here. Mock trial is no easy task. It is one that takes severe dedication and commitment. And for Taylor to simply throw all that away for the sake of Avery really shows us his character, does it not? You cannot trust Taylor Perkins' testimony. Now, before we continue on to the investigation, we will address the ridiculous claims of the defense, and especially Blake Van Owen. They suggest that this was a lousy investigation, yet fail to see the irony in their own reasoning. Van Owen was hired for the sake of creating a poorly put together story. And in reality, their testimony and report seek to manipulate you, ladies and gentlemen of the jury. Van Owen's job is no more than always being on the police department's side, purely biased, all smoke and mirrors and no substance. Our job as the prosecution is to meet the burden of proof. And here, Van Owen seeks to raise doubt that is quite unreasonable. Now, let's move on to the day of the murder, March 6th, 2020, where through Detective Markowitz and her expert testimony on the cell phone data, we can track Avery's phone to the home of Brackman. Mackenzie's Brackman home, where he should be able to relax and feel safe. However, for Mackenzie Brackman, his home was not as such. Avery Becker, after attempting to enter through the front door, as we see on the Ring videos, feloniously broke into the house from the back, unarmed and with the intent to cause criminal mischief. Once again, going back to the text reviewed by our experts. We then see, through Kuzak's testimony, that the victim was alerted to the intruder in fear of his life, looking for a way, any way, to defend himself. He grabbed the knife, in turn leaving the knife drawer opened, and defended himself from the intruder. In the process of such a vile act of breaking in, Brackman was killed, while Avery was still there. The evidence demonstrates that Avery unquestionably was responsible for these gross undertakings, leading to the death of Brackman, proving without a doubt that Avery is indeed guilty. Ladies and gentlemen of the jury, we have worked hard to present to you unquestionable evidence, and now it is your job to do the right thing. Return a verdict that Avery Becker is guilty of the crimes charged. Thank you for your time, ladies and gentlemen of the jury.
I would just like to inform counsel that he has 1 minute and 15 seconds for a rebuttal after.
Thank you. Defense, are you ready to proceed with your closing?
Yes, Your Honor.
Please do so.
Alrighty. Opposing counsel and members of the jury, we all came here today for the same reason. Not only to preserve the theme of justice so embedded in this criminal system, but more specifically, the truth. Now, the prosecution today assumed the burden of proving beyond a reasonable doubt that Avery Becker is guilty of second-degree burglary, first-degree felony murder, and criminal mischief. All three aspects must be proven beyond a reasonable doubt. They were not. Furthermore, the prosecution today also assumed the burden of upholding the importance of finding the truth. And the prosecution today failed to find the truth. Their case was an illusion of a tree, yet as the defense looked closer, we found no root. Instead, neglect, spite, and envy. There was neglect intertwined with Detective Markowitz and the way this case was conducted. Rather than being sure about her findings, the detective was always barely sure. Furthermore, she admitted that, quote, the fact that Brockman did criminal defense work raised suspicion that this could be the work of a disgruntled ex-client. Yet Detective Markowitz did not follow up on this implied lead at all, and good police work requires one to follow up on all leads. This did not happen. Good police work was not achieved. This case was neglected because of the lack of an adequate investigation. There was neglect tied to every aspect of Kyle Kuzak's case. A civilian, although with credentials, did not fully investigate this murder, nor did Detective Markowitz encourage this level of investigation, perhaps because of the former relationship with Brockman that Detective Markowitz had. And Kyle Kuzak's suspect list was incomplete, and proves an adequate investigation was not complete. Ms. Kuzak even states in her direct questioning today that, quote, there are possibilities as to what could have happened, yet no definite conclusion could be drawn from the evidence. Moving on to the last witness you heard today, Alex Cifuentes' claims were covered in spite, stemming from his inability to allow someone else to succeed. Mr. Cifuentes, fueled by envy, found the best way to destroy a legacy of a fellow classmate and team member. It was a known fact that Mr. Cifuentes and Ms. Becker constantly competed on the mock trial team. This spiteful nature had been brewing for years and reached an all-time high when he saw an opportunity to finally win. Neglect, spite, and envy twirled around the prosecution's case like the snake in the Garden of Eden, twirled around the burden that the prosecution did not meet. The prosecution did not meet their burden of proof. The defense, however, met the burden of truth. We proved in court today the innocence of Avery Becker, an ambitious, intelligent, and innocent teenager on trial for the murder of her mentor today. We proved that Miss Becker was incapable of murder. She acted out after conflict with Brockman, yes. However, she quickly de-escalated and became remorseful and attempted to make amends with a coach, an aspect that was not investigated. We proved the innocence of Avery Becker with our other witness, Taylor Perkins. Miss Perkins not only spoke to the character of Miss Becker and her ambition to mock trials, but he spoke to the whereabouts of Avery Becker at the time of the murder. It is not possible to be in two places at once in opposition to what the prosecution is implying by attempting to convict a young woman who has an alibi. Finally, we proved the innocence of Avery Becker with Professor Blake Van Owen. Professor Blake Van Owen not only filled the holes left in the investigation by the police, but he's an experienced private investigator and speaks to crime scene reconstruction, cell phone tower analysis, and an expert opinion in general police practices. Professor Van Owen testified to this case being rushed, and by extension, much was missed in this investigation. Van Owen completed the necessary police work and came to the conclusion that a disgruntled former client of Brockman was indeed a likely suspect. Now, members of the jury, this is not deja vu. Detective Markowitz admitted that Brockman's profession made him a likely victim for a former client. Blair Rollins is the son of a former client that has no alibi, has motive, and was missing on the day of the murder. This was not investigated. This was neglected. Neglect, envy, and spite, all embedded in the mere structure of the prosecution's case. Ladies and gentlemen of the jury, we all came here today with one goal, to find the truth. The defense today found the truth. The defense today proved that it is not only unlikely, but impossible for Miss Becker to have committed the murder of her mentor. I ask you to look past the rootless tree of envy, neglect, and spite that the prosecution attempts to plant in our minds today. I ask you to be on the side of truth. I ask you to find Avery Becker not guilty of second-degree burglary, first-degree murder, and criminal mischief. Thank you for your time.
Prosecution, do you wish to use the time you have for rebuttal?
Yes, Your Honor.
Please proceed.
Neglect. Neglect. Everywhere in Van Owen's case. As simple things as analyzing the ring videos, not even considering the noises the door makes. He fabricates an entire idea out of nothing. Clearly, as we see JT point out, he pokes holes through Van Owen's arguments with ease. Spite. Avery was very spiteful of Brackman, constantly pushing against Brackman, would take to extreme measures just to make sure that Avery got her way. She vandalized Coach Brackman's car after being upset by Brackman. She was not in control of her emotions, and neither was she the day of March 6th, the day of the murder. And now, Taylor Perkins. They brought Taylor Perkins as an alibi. Out of convenience sake, the witness, best friend of Avery, who would do anything for Avery, would sacrifice his position on mock trial. They would do whatever they could. The defense has lacked any proper motive with this case investigation and only sought the easy way out. Thank you, Your Honor.
All right. Okay, normally if this were a real trial, the judge would read the instructions to the jury and it would be submitted to the jury. Fortunately for all of us, we don't have to go through that step. So the case will be deemed submitted at this point. And while the scorers are finishing up their score sheets and submitting them, we can all relax. So please do so. The next step, if the teams wish to do so, is a brief feedback session. It's late, but I do have a few comments, and I imagine the scorers do as well. And if you want to hear some feedback, we'll be happy to provide it very briefly. Do I hear any objections?
No objection,
No
Your Honor.
objection, Your Honor.
Okay, all right. Well, we have to wait for the scorers to finish their work, and then I will give the scorers an opportunity to provide some chat, and then I'll have a few comments. So let's just.
Score sheets are all in, so you guys can go ahead with comments.
Okay, thank you.
Yep.
Scorers, I'd like you to provide your feedback first in any order. I would ask you, as I've been asked as the presiding judge, for you to keep it short. We're supposed to keep it anywhere between 2 and 3 minutes maximum. And it's even been suggested that we keep the timers busy and have them time each of your comments. I've never done that, and I don't think I will. But I might say time if there's some rambling that's going on. So let's go ahead. Keep it brief. We're all hungry. Sarah, why don't you start things off?
Okay, but watch this. This is going to be really quick. You guys were fantastic. I want to say quickly, both closing arguments, outstanding energy for how long you guys have been at this all day. You really brought it back up. You took it all the way home. I was completely engaged right until the end. So I really liked that. I really liked the energy in the openings as well. Both themes resonated with me from each side, and the tying that whole thing together all the way back to the end was really good. I thought you guys did a really nice job on that. Don't give up on your objections so quickly. You guys have got this. Some of that evidence could have come in. Some of those questions could have been asked again. So you know the material, be confident in your positions. Just be really tight with them. If you feel like it's getting away from you and you're giving up because you feel like you're losing time, just be really solid in why you're objecting and why you think your evidence should be in. And I think you'll see more of those come in and more of those lines of questioning when you need them. So that's the positive and the constructive, and we'll go on to the next folks.
Okay, thank you. Who wants to be next?
I can go, Your Honor. Kip Kochmeyer.
Okay.
So I thought this was a very close round. You guys did a great job. The challenge in a virtual environment is to remain focused, staring at the camera, engaged. And for witnesses, that means, you got to have some personality. I thought Nathan and Dominic and others did a really good job of having personality as witnesses. And for the attorneys, it's important to not be reading if you can avoid it. We can kind of see the eyes going back and forth as you read. If you can really be focused on the camera and focused on the jury, that would be great. I agree with Sarah that the themes came through. The weakness of the case for the prosecution is, did this high schooler really go from markers to murder? And then from the prosecution side, they were able to, they talked about how she was devastated. She was volatile, push, push, push. So I thought both sides did a good job of pulling those themes out. There was some trouble on exhibits. There was some trouble getting things in. And one important thing to remember is there's a difference between asking a witness, Does this picture accurately represent what you saw? And laying a foundation for that particular exhibit. There's a series of questions that should be asked to establish that foundation. I think this was a bit of a challenge in this round. The foundation is called the foundation because it's the basis upon which the exhibit rests. So, who took the picture? When did they take it? Was it in the regular course of business? So that's something that I think could have been worked on. I thought, Skylar, you did a particularly good job on this very issue, though, when you were getting in the text messages from Alex. I thought that was a good example of laying the proper foundation, and it was very well argued on the objections. The last thing I'll say is on cross, and I suspect this is a coach's suggestion, so I may be in the minority on this, but the notion of starting your cross by telling the witness they better answer yes or no, I'm not a huge fan of that, because one of the things that demonstrates an effective cross is if you have a hostile witness who's being evasive, then you can get control of them, rather than starting by saying, I only want to hear yes or no answers. But others may disagree about that. I would just mention that I think Mr. Dar did a particularly good job on his cross by really concise statements. They were super short, super concise, and if there wasn't a good answer to it, then you could tell that the witness was evading. Personally, I like that a little bit better. But great job overall, and it was very enjoyable to score this round. Thanks.
Thank you. Who's up?
I'm happy to go next.
Go ahead.
Oh.
No, go ahead. Go ahead.
First of all, I think everybody was very well prepared. I am always impressed by the work, the hard work. My daughter did mock trial for a long time, so I know how much work goes into this. I'm going to kind of harp on both sides about objections. Juries hate objections. They want to hear the evidence. They want to hear the story. And I think that you have to be very careful about objecting. And I think my criticism of both sides is that I think you did too much, and that you need to be much more strategic about what issues you're going to really object on. And then when you get the objection, as Kip mentioned, or actually I think it was Sarah, you got to fight back. You can't let go. And that means knowing these rules cold and, go back to the old flashcards. And my daughter had flashcards, and my daughter knew the rules so well. She came to trial with me and was passing me yellow stickies about what rule I should be applying in my case. So you got to know them cold. And you got to apply those to the objection and to the facts. And so you've got to be real strategic about that. The other thing that I noticed, and again, this is both virtual, but I see it in a courtroom as well, and that is, don't draw attention to yourself as the lawyer when you're doing direct examination. And I noticed some of you had some hand movements, and you would be kind of pushing hair back and things like that. And it's hard because you don't think about a lot of that stuff, but those things can be distracting. And you don't want to call attention to yourself. You want your witness to shine. And when you call attention to yourself as a lawyer, it's on cross-examination. And I actually thought all of you did great on cross-examination. I thought, again, as Kip mentioned, a lot of the questions were very tight. They were good. So again, congratulations. I agree. It was a tight round, and I think you all did great.
Maria.
Okay, well, I don't have much to add. I really enjoyed this. I very much appreciate how you tried to impeach your witnesses. I thought you did a great job. And I think you did a great job on Zoom, that you could acclimate yourself to using this for a trial. I think that you did an excellent job.
Okay, I just have a couple of comments. I agree with most of what the scoring panelists have said. One of the things I really enjoy about doing this is to observe the cross-examinations. And I thought they were very good on both sides, but I think one really stood out, and that is TJ's cross-examination of Blake Van Owen. And just one of the reasons it was good is because he's such an important witness. He is the only expert that was called to counter the two experts that the prosecution, prosecution called. So it's important to cut him off at the knees. And TJ, I think you cut him off at the waist. You did a great job. We finally got the exhibit to make some noise on opening the door, and it was just extremely well done with that, even with that kind of mechanical glitch. And the follow-up to that was from the witness was that there was a car going by, so there was lots of other noise. Well, if there was noise opening the door, that let in the noise from the car going by, and maybe or maybe not, that was enough to arouse the victim to look around and see what was going on. But you sure raised the question, and that was very skillfully done, and I commend you on that. And the other thing, in that same cross-examination, in the witness's report, it's the first thing I noticed about it. And that was that he said he was asked to give the following opinions, and then he listed them. And I got to tell you that is a rookie mistake by an expert witness, but it happens. And I know because I've experienced it in both sides. And fortunately, when it was my expert, I caught it and we modified the expert's report. But what that does, it cuts drastically into the credibility of the whole entire rest of the report. And what you did was you pointed out that, and then you left it. You left it for the jury to say, well, if he was just doing as he directed by his client, why do we have to believe anything that he says? Without going into the details of that report. It was very well done. I was impressed. And I don't know if it showed, but I was sitting here grinning while you were doing that. It was fun to watch. So great job. And the other thing, and I'll be very brief on this, is the closings. They were both very well done, but I think particularly Emily's closing, good eye contact, good substance, and what we don't see very much in this context is passion and emotion. And in this case, it was very appropriate to show that emotion. And Emily, you did a great job. The only quibble that I have is please slow down. I was exhausted at the end of your closing. Slow down and pause. Use some pace. Make breaks between your points, just for a second. But substantively and from the standpoint of emotion, it was an excellent job, very effective, I think, and affecting because of the passion that you showed. So those are a couple of things that impressed me particularly. It was a close match, well coached, I will say, and I enjoyed this. So thank you, team members, and also I don't know if anybody what would be in the gallery, the family and friends and coaches are listening to this, but if they're not, I'd like the team to pass this on, that I appreciate their participation in this process. They are very important to the success and the quality of these presentations because of the support that they give to you teenage kids who are working hard most of the time. And it's great to have the support from your friends and your family, your siblings, aunts and uncles, your great grandparents, whoever it may be. So I am thanking them. And if I need to thank them through the teams, please pass it on if they're not listening now. I appreciate their participation almost as much as I appreciate those from the kids, from the team members, and the work you've put in. So thank you all, and good luck to both teams in the next 2 rounds. Tomorrow's going to be a big day. Go home and get some sleep.
Thank you, guys. Thank you to my volunteers. We couldn't do this without you.
All right. Thank you all.
Thank
Have a
you
good
so
night.
much.
Thank you, Your Honor.
Okay, I'm clicking end and it's not ending. Why is that?